Before the debate is resumed on this bill, I remind the Federation Chamber that it has been agreed that a general debate be allowed covering the bill and the secrecy provisions amendment sunsetting provision Bill 2026. I call the member for Clark.
And I thank you, Deputy Speaker. Deputy Speaker, minimising secrecy and maximising transparency are obviously building blocks of a healthy democracy and are to be applauded. So this is a worthwhile bill and it's obviously supportable. It's supportable not just because of what it does, but also because of the way it reminds us of what the government isn't doing, which is why I moved the amendment circulated in my name, and it's very brief, Deputy Speaker, so I'll read it out, that all words after that be omitted with a view to substituting the following words. Whilst not declining to give the bill a second reading, the House 1 notes that Australia has been described as the most secretive democracy in the world due to the proliferation of national security, counter-terrorism and secrecy laws and the lack of whistleblower and public interest journalism protections. And B, despite the Labor Party promising in its 2021 platform to overhaul and improve Australia's whistleblower protections, only small changes have been introduced to date and protections remain patchwork and inadequate. And 2, calls on the government to introduce comprehensive reforms to the Public Interest Disclosure Act and the Corporations Act to better protect whistleblowers. B, introduce comprehensive reforms to the Crimes Act and Criminal Code and Evidence Act to better protect public interest journalism and media sources. C, establish a whistleblower protection authority to oversee public and private sector whistleblowing. And D, establish a federal whistleblower reward scheme encouraging whistleblowers to come forward and expose wrongdoing. Deputy Speaker, I pursue this matter at this time because, frankly, whistleblowers matter. They're one of the most fundamental building blocks of our democracy and one of the fundamental ways that we bring genuine transparency to the way this country is run. Deputy Speaker, where would we be? Where would we be without someone like Tony Hoffman, who you'd recall was the nurse at Bundaberg Hospital who blew the whistle on Dr Patel and the tragic death that occurred there over a period of years? Where would we be without Alan Kessing? He was the Sydney Airport Customs Officer who blew the whistle on the security lapses at Sydney Airport. Where would we be without Jeff Morris? He blew the whistle on misconduct at CommBank and the incompetence in ASIC and was one of the reasons we ended up having a Royal Commission into the financial services sector. Where would we be without Richard Boyle? He blew the whistle on the egregious conduct at the Australian Tax Office in Adelaide. David McBride, who blew the whistle and provided the evidence of war crimes in Afghanistan. And in my own work, Deputy Speaker, there's been a number of whistleblowers that I've helped facilitate the disclosure of their information. Deputy Speaker, you might remember the information that was revealed about Crown Casino. And I'm mindful of the Crown whistleblower who provided me with the video footage of a group of young men in a private gaming room laundering literally an Aldi freezer bag full of cash, which was estimated to contain about $2 million, all because of a whistleblower. Troy Stoltz, the former Clubs New South Wales compliance officer, who provided the evidence of non-compliance at up to 95% of money laundering and counter-terrorism legislation in registered clubs in New South Wales. What about the AFL whistleblower, the doctor for Melbourne, who revealed the evidence of secret drug testing within the AFL? Where would we be without the very brave whistleblower about the Hillsong Church, who provided, and I think it was in this chamber, on her behalf, I tabled something like 17 folders of hard evidence of shocking financial misconduct by the leadership of the Hillsong Church. Deputy Speaker, these people should be celebrated, but instead they're ridiculed, persecuted, charged, jailed. Just look at those examples I've given you. Tony Hoffman was undermined and ridiculed. Alan Kessing was charged and convicted. Jeff Morris, the bank whistleblower, was sacked by the bank. Richard Boyle from the ATO, he was charged and mercifully there was no conviction recorded. David McBride, of course, is in jail only several kilometres from here where we meet today. Troy Stelz, he was taken to court by Clubs New South Wales. The AFL whistleblower, ridiculed within the AFL and beyond. And the Hillsong whistleblower, that whistleblower is before the court as we speak. And in fact, there's an AAP story circulating today about what's going on there. In other words, Deputy Speaker, the protections just don't work for these people, whether they be in the public sector and are relying or leaning on the Public Interest Disclosure Act, or in the private sector, perhaps relying on the relevant sections of the Corporations Act. They're just not working. And there was, in fact, this is very timely, Deputy Speaker, there's no better evidence of this than the report in the Australian Financial Review just, 3 days ago on the May 10th regarding Neo Metals executive Christian Riker, who thought he was a whistleblower when he flagged governance and strategic risks at the battery technology company. In fact, I met with Christian Riker about a year ago, and from memory, one of the issues was an allegation of theft of intellectual property when it came to whatever Neo Metals was pursuing. But in a and I'll read this from the Fin Review so I'll get it right, please, Deputy Speaker. In a major judgment, the federal court has backed the company's decision to make Riker redundant, finding that because the board and CEO subjectively believed Riker's complaints were unfounded, or that it was simply part of his job to raise such matters, that because of that, he was not protected by the whistleblower laws. Now, if those who are listening to me are struggling to understand what I just said, I don't understand it myself. I think, in other words, this whistleblower is witness to serious misconduct. He speaks up. He thinks he has the protection of the relevant part of the Corporations Act. But because the management didn't regard him as a whistleblower, then he's not protected by the whistleblower protections. Now, that's not a criticism of the court in any way, Deputy Speaker, because the court entirely appropriately applied the law as it stands. The issue is that the law's a crock. In fact, isn't it interesting that there has not been one successful whistleblower in a compensation claim under both the federal public sector and the private sector whistleblower laws. Not one successful claim for financial compensation under any of those laws since they've existed. Surely that is all the evidence we need, Deputy Speaker, that they need to be improved. Now, I'm delighted to see the Attorney General in the Federation Chamber, and I do note that the government has been working on reform for some time. In fact, for at least the last 4 years, the Labor government has been talking about reform, have acknowledged the need for reform. Consultations have come and gone. Consultations are forthcoming, I think, on the Corporations Act. But, we measure success by outcomes. And the Public Interest Disclosure Act has not been amended in any substantive way except for a few technical changes, dotted a few I's, crossed a few T's. There hasn't been the deep reform of the Public Interest Disclosure Act that is needed. And the Corporations Act, I don't think that's been touched ever since Senator Rex Patrick did fabulous work in the Senate some years ago to get those provisions put into the Corporations Act. So, Deputy Speaker, through you, I say to the Attorney General, we've really got to get cracking on this. We've really got to get cracking on this. And not just the PID, but the Corporations Act as well. I mean, I just find this unfathomable that Christian Riker was witness to misconduct, and I've spoken to this man personally. I am satisfied that he was witness to misconduct. But because the management at Neo Metals didn't regard him as a whistleblower, they thought it was just part of his normal job to observe things like intellectual property theft, that the relevant part of the Corporations Act doesn't apply. I think that's a very, very timely example that I'm able to bring to the Attorney General's attention through you, Deputy Speaker. Deputy Speaker, of course, it's not just amending those acts. There is also the pressing need for an independent whistleblower protection authority like exists in a number of countries around the world. Because the fact is that whistleblowing in this country is diabolically difficult. It's incredibly difficult. For a start, you've got to be able to safely collect the evidence of your complaint. And we saw with Richard Boyle, the ATO whistleblower, that although I think from memory the court understood he was a whistleblower, they found he wasn't protected by the relevant act because his collection of evidence was not covered by the act. Well, how can you blow the whistle if you can't collect the evidence? So the legislation is complex, and frankly, unless you're a lawyer in this area, or unless you can go to something like an independent whistleblower authority to get advice, then you're behind the game right from the start. There's such a high likelihood that you're going to stumble and fall foul of the law, just like Richard Boyle did. Fortunately, there was no conviction recorded against Richard Boyle in the end. And then, apart from just understanding the law, just someone to mentor you through the process. Because, take the Public Interest Disclosure Act. There is a convoluted process, and it's a series of hoops you have to jump through. And you need someone to sort of figuratively hold your hand and guide you through all of those hoops. Otherwise, you will be run foul of the law. So that's something I think that we need to turn our mind to, Deputy Speaker. It's come up from time to time in public utterances by the government. It exists in a number of other countries, and it's something that would be very, very worthwhile. Deputy Speaker, I won't detain the House any longer. I would just say in closing, yes, minimising secrecy and maximising transparency are building blocks of a healthy democracy and are to be applauded. So I say through you to the Attorney-General, this is a worthwhile bill, and I would hope it has the unanimous support of everyone in this House and in the other place. But it's almost a clarion call to get moving on all the other stuff, the big stuff, the more important stuff, the more helpful stuff, the stuff that will show whether or not this government has real integrity and it really is committed to minimising secrecy and maximising transparency, and to celebrate the people who speak up and speak truth to power. And by the way, I rattle off about 10 examples there of particular individuals. We should also be mindful of the thousands of Australians who speak up in all sorts of ways, whether it be about the organisation they're a member of, the business they're an employee of, maybe about their local council, any number of things where people speak up. And for many of those whistleblowers, it ends in tears. They will be bullied in the workplace, they'll be managed out, or they'll be just blatantly sacked. They will be ridiculed, marginalised. It leads to financial troubles. It leads to relationship troubles. No wonder the suicide rate for whistleblowers is markedly higher than the baseline rate in our community. Whistleblowing in this country is almost impossibly difficult. And, I'm pleased people like Tony Hoffman, Alan Kessing, Jeff Morris, Richard Boyle, David McBride, Troy Stoltz, I'm pleased they have enjoyed the publicity and the public support they have. But spare a thought for the thousands of other Australians who speak up and the local paper won't even give them the time of day, let alone having a story on the news that night, let alone capturing the attention of the media for a protracted period of time to really make the case and to really sort of sandbag their position and be in a stronger position publicly. In closing, Deputy Speaker, I'll just say, while all of the hullabaloo caused by whistleblowers might well be a bugbear for organisations, they are nonetheless grist to the mill of Australia's democracy, and they must be supported and indeed celebrated and not be the tall poppies that some people make them out to be. Thank you, Deputy Speaker.
Is the amendment seconded?
I second the amendment and reserve my right to speak.
The original question was that the bill now be read a second time to To this, the Honourable Member for Clark has moved an amendment that all words after that be omitted with a view to substituting other words. The question is that the amendment be agreed to. I call the member for Sturt.
Thank you, Deputy Speaker. I rise today to speak in support of the Secrecy Provisions Amendment, Sunsetting Provision Bill and Secrecy Provisions Amendment Repealing Offences Bill. And before I do acknowledge the contribution from the member for Clark and share his views that the disclosable conduct regime in the Public Interest Disclosure Act, Taxation Assessments Act and Corporations Act are complex, but they are complex for very good reasons. And put some of his concerns to rest that legislation does in fact contain robust protections for whistleblowers and robust processes and procedures that organisations in receipt of disclosable conduct submissions must follow. Any reform to those powers and those processes must be done with significant degrees of care and consideration, given the consequences and the magnitude of the making of disclosable conduct. Firstly, turning, however, to the bills currently before this chamber, what are secrecy provisions? These are provisions designed to prohibit the disclosure of sensitive information held by government, including some types of personal, commercial, national security and law enforcement information. Secrecy provisions exist not to hide, to obfuscate, to confuse or to concentrate power. They exist to prevent harm to essential public interests, such as national security, and they provide assurance to people and entities who provide information to the Commonwealth that their information will be treated appropriately. There is a need for secrecy laws, but of course these laws must be balanced against both the public interest and the fundamental democratic principle of open and accountable government. Secrecy provisions must be justified within that system of open and accountable government and in a manner consistent with the right to freedom of expression. Now, this requires a balance between the desirability of open government and the legitimate public interest in protecting some information from disclosure for those important reasons, including national security, defence, international relations and privacy. Now, this balance must be clear and it must be appropriate. It's not easy. On one side of the coin, it is critical that Australia's law enforcement and security agencies have access to powers which may, in certain instances, have the effect of curtailing certain freedoms. Now, this is in order to allow for the proper investigation of serious offending and the obtaining of intelligence regarding legitimate threats to essential public interests. The other side of the coin reflects Australia's democratic values, the rule of law and human rights considerations, which dictate that official secrecy provisions must be tempered by a critical right, which is the public's right to accountable government. Secrecy provisions need to be ring-fenced and proportionately so to the disclosure of information which would undermine national security or endanger citizens. It is simply a fact that some information held by the Commonwealth must have its integrity and security protected. This is not secrecy for secrecy's sake. This is a genuine purpose. Secrecy provisions must be frequently measured and performance tested to make sure that they reflect this genuine purpose and to make sure that the balance between the genuine purpose, the public interest and human rights is being appropriately and proportionately struck. Drawing on the 2023 review of secrecy provisions conducted by the Attorney-General's Department and the government's response to the Independent National Security Legislation Monitor's 2024 Secrecy Offences Review of Part 5.6 of the Criminal Code Act of 1995, this bill comprehensively tests and reforms Australia's secrecy provisions. So by way of background, on 21 November 2023, the Albanese Labor government announced it would introduce reforms to Commonwealth secrecy offences to significantly reduce the number of secrecy offences, ensuring remaining offences were fit for purpose and that it would improve protections for press freedom. The independent national security legislation monitors 2024 review, which looked at Part 5.6 of the Criminal Code, helped to shape this. So Part 5.6 of the Criminal Code includes offences that apply to Commonwealth officials, including contractors, who disclose or otherwise deal with what is defined as inherently harmful information, or information that falls into a category defined as causing harm to Australia's interests. So these definitions of inherently harmful information and causing harm to Australia's interests are central to how these very serious offences operate, and so they must therefore be clear and certain. Part 5.6 also contains a general offence pertaining to officials who breach a duty imposed by another law not to disclose information, and an offence in Part 5.6 that applies to any person, not just officials, who disclose specified types of information, including information with a security classification of secret or top secret, applied in accordance with the Commonwealth policy framework. For prosecutions in this regard to be effective, certainty and clarity about what this all means in practice is required. So asking whether Part 5.6 is working effectively required a consideration
I would
of
appreciate
what can...
that the member be heard in silence.
This requires a consideration of what can only be described as really complex questions, such as how potential breaches of secrecy obligations are actually handled in practice, what national security or other harms the criminal offences aim to address, as well as the threshold questions of when a deemed harm offence is appropriate, what they should cover and who they should apply to. These are complex issues, and multiple reviews of Australian laws relating to secrecy found that the provisions, probably in response, had become complicated, outdated, too broad, and in some cases no longer essential. The latter finding of essential cuts across the principle of the genuine purpose of secrecy provisions, creating a risk that justifiable information sharing can be compromised, which only undermines trust and creates suspicion that the genuine purpose is not appropriately reflected in the law. Scope creep, or death by a thousand cuts, whatever you call it, when new baselines are constantly set, cannot be the way to legislate. So this bill, quite rightly, makes comprehensive reforms to Australia's secrecy framework in response to these findings. So the bill itself and its practical impact. Firstly, to criminal liability. The 2023 review of secrecy provisions that I referred to earlier found that there existed 168 provisions that no longer required criminal liability, but which still attracted it. Following a period of extensive stakeholder consultations led by the Attorney-General and involving contributions from multiple departments and agencies, criminal liability will be removed from more than 300 secrecy provisions, which will take place by repealing and amending specific legislation. Significantly, Section 122.4 of the Criminal Code will also be repealed. Courtesy of Section 122.4A, the offences in this section apply to people who are not Commonwealth officers in relation to information they communicate or deal with, or which was made or obtained by another person by reason of that other person being or having been a Commonwealth officer or otherwise engaged to perform work for a Commonwealth entity. So what this means is that Section 122.4A offences would arise if the non-Commonwealth officer communicates or otherwise deals with information, and among other things, the information is security classified, or communication of it interferes with or prejudices enforcement of Commonwealth criminal law, or harms the health or safety of the Australian public. These offences are extremely broad, and the repeal means that the vast majority of these non-disclosure duties will now be subject to more proportionate civil and administrative sanctions, meaning criminal liability will only arise where strictly necessary to protect sensitive information, again better reflecting the genuine purpose of secrecy laws. Deputy Speaker, this is significant reform. Also, to be clear, this bill will introduce a much more targeted and refined secrecy offence into the criminal code. Now, this is not a broad, general secrecy offence that criminalises disclosures that are detrimental to the working of government, which is what the 2023 review recommended. This would be too broad and undermine trust in the criminalised aspects of the secrecy framework. The bill instead seeks to close gaps that were previously identified following the much reported unacceptable conduct of a former PwC partner who allegedly shared confidential Commonwealth information for personal and professional gain. The targeted secrecy offence will address this type of conduct, which will apply to Commonwealth officers and persons connected to the Commonwealth, and where these persons improperly communicate or use Commonwealth information to obtain a benefit or cause a detriment. Finally, press freedoms are contemplated and enhanced by the Repealing Offences Bill. Appropriate protections that promote freedom of the press are growing in importance. We know that if there is an erosion of press freedoms, it is a signal of the erosion of an efficient, effective and functioning democracy. In 2025, the World Press Freedom Index, compiled by Reporters Without Borders, was at its lowest point in the index's 25-year history. Journalism is being increasingly criminalised, and political hostility to the press is creating a very uneasy climate where speaking out can compromise one's personal safety. We see it time and time again across the globe, including increasingly in countries which we would traditionally have regarded as fully functioning democracies that have historically embraced freedom of the press. In 2025, Norway topped the index, and we must all strive to meet them where they are at, which is a media market that is vibrant, featuring a strong public service broadcaster and diversified private sector services with extensive editorial independence. Fair and genuine public interest journalism, that is fair and genuine public interest journalism, must never be endangered. Journalists and the press play an important role in providing information to the public, in holding governments to account, in investigating matters of national significance, and ultimately, in some cases, shaping policy decision. This work, when it is done fairly, must never be encumbered. So the bill therefore contains a new requirement that the Attorney-General consent to the prosecution of a journalist for any secrecy offence, with the goal of this being that it must be absolutely clear that any proposed prosecution is in the public interest before it proceeds, noting two things. Firstly, that protected matters like providing information to the public, holding governments to account and investigating matters of national significance are firmly part of the public interest. But secondly, that certain information relevant to national security and law enforcement or highly sensitive commercial and personal information must also be protected from disclosure. So significant amendments will be made to the secrecy offences that apply to non-Commonwealth officials, including journalists. The practical effect of this is that non-officials are subject to a higher threshold for criminal culpability than Commonwealth officials by increasing the thresholds to trigger criminal liability. Achieving the genuine purpose of secrecy laws is challenging because it involves a combination of secrecy, transparency and accountability. But that purpose must always be achieved, because if it is not, public confidence in the secrecy framework is eroded. And once this is damaged or gone, the challenge in trying to regain that trust is almost insurmountable. The Secrecy Provisions Amendment Repealing Offences Bill seeks to strike that balance between secrecy, transparency and accountability. And I stand with the Attorney-General in bringing this bill before the Parliament and the work that she has done in revisiting Australia's secrecy laws, and I commend the bill to the Chamber.
I call the member for Curtin.
Thank you, Deputy Speaker. I rise to support the Secrecy Provisions Amendment Repealing Offences Bill. Repealing more than 300 unnecessary secrecy offences is long overdue, and I commend the government for acting on years of careful review by the Australian Law Reform Commission, the Attorney-General's Department and the Independent National Security Legislation Monitor, or INSLM. For too long, Commonwealth law has imposed criminal liability across a vast sprawl of non-disclosure obligations, provisions that have accumulated without coherent review and that sit far beyond what any principled framework of criminal law would endorse. That accumulation was not the product of deliberate policy, but rather legislative drift, and it has entrenched a culture of secrecy that weakens rather than strengthens accountable government. Repealing more than 300 of these provisions is a meaningful reform. It will make our laws clearer and more worthy of trust from the people they govern. But I'm concerned about the new general secrecy offence it introduces, the replacement for section 122 subsection 4. It gets the balance wrong in ways that matter. The government's own independent reviewer, the INSLM, has been clear. Any new general offence should be harm-based and directed to essential public interests, with criminal sanctions reserved for disclosures that cannot be adequately addressed through administrative or contractual means. The bill does not do this. Instead, the new offence turns on whether it would be reasonable to conclude that a use or communication of information was improper, a concept that's undefined and dangerously vague. Improper is not a harm, but a broad, uncertain standard of conduct that no independent reviewer recommended. The government agreed in principle with the INSLM's harm-based approach, but this provision does not reflect that agreement. The uncertainty this offence creates is a problem. Consider a public servant who mentions to a former colleague that their agency is tendering for a particular contract, where that information hasn't yet been published. Is that improper? Well, it may well be. Consider a peak legal body that receives a confidential exposure draft of legislation precisely so it can consult its specialist committees and provide informed feedback. A lawyer who circulates that draft internally is doing exactly what the consultation process requires. But are they exposed? Well, arguably yes, if sharing the draft confers a benefit and the confidentiality terms were explicit. Now, the government might say that none of these people would actually be prosecuted. And that may be true, but trust us is not a principle of criminal law. People are entitled to know in advance whether their conduct is lawful. Improper does not tell them and risks having a chilling effect on consultations, civil society and public interest journalism. The first amendment that I'm going to move in consideration in detail will address this. It replaces the improper test with a harm-based threshold. The offence would only be committed where the communication harms or the person intends to, or is reckless as to harming an essential public interest. The amendment defines essential public interests as national security and defence, criminal justice integrity, public health and safety, financial system stability and the privacy of personal information held by the Commonwealth, while making clear that the courts may recognise others as well. Critically, it also makes clear that a communication does not harm an essential public interest merely because it exposes wrongdoing, maladministration or a failure of public accountability, protecting the space for whistleblowing and public interest journalism without creating an unlimited defence. My second amendment that I'll propose addresses the Attorney-General's consent mechanism for journalist prosecutions. Now, I support this mechanism, but not without reservation. Politicians should not, as a matter of principle, be final arbiters in the functions of our criminal justice system. But in the absence of stronger protections, or including a general public interest defence or effective whistleblower laws, this mechanism is desirable in practice and may safeguard against prosecutions that would otherwise proceed contrary to the public interest. Well-balanced secrecy laws would negate any need for the Attorney-General to act as a final safeguard at all. My second amendment will therefore require a mandatory independent review every 5 years to assess whether this mechanism is working as intended and whether it remains necessary, with findings reported to the Parliament and a government response to any recommendations required. Open government is a condition of democratic accountability. Secrecy is sometimes necessary, but it must be the exception, and it must be justified by reference to real harm to real public interests. While the bill makes important progress, the amendments that I'll be proposing in consideration in detail would ensure it goes further, anchoring the new general offence in the harm-based framework that independent reviewers recommended, protecting journalists and civil society, and building in the accountability mechanism this reform deserves. I really want to support this bill. Repealing more than 300 secrecy provisions and simplifying this would be a step in the right direction towards more open and accountable government. But replacing them with an offence that turns on whether the use of information was improper is dangerously vague. It's not consistent with the harm-based approach or the focus on essential public interests advocated by the INSLM or the Law Council, which the government agreed with in principle. I urge the government to consider my amendments in good faith, making the new test harm-based and directed to essential public interests, and including a 5-yearly review to make sure that the Attorney-General's consent mechanism for journalist prosecutions is actually working as it should. These are reasonable changes, and if the government agrees to them, I will happily support the bill.
I call the member for Wentworth.
Deputy Speaker, I rise in support of the Secrecy Provisions Amendment Repealing Offences Bill 2026. This is some of the most significant reform to the Commonwealth secrecy law in decades. It draws on 2 major reviews, the Attorney-General's Department Review of Secrecy Provisions complete in 2023 and the subsequent independent statutory review by the Independent National Security Legislation Monitor. I commend the government for acting on these findings. Secrecy provisions are necessary. They protect national security and intelligence and ensure that those trusted with sensitive information can be held to that trust. But as a Human Rights Law Centre put in their submission, secrecy laws which are disproportionate and not properly calibrated are bad for Australian democracy and the rule of law. This bill moves meaningfully closer to that balance, though not all the way there. I understand the bill has been referred to the Senate Legal and Constitutional Legislation Committee. I hope the issues I raised today are considered carefully and that the government responds to the committee's recommendations before passage. The 2023 AGD review had confronting findings. Commonwealth legislation had accumulated around 875 secrecy provisions, which was enough for the New York Times to describe Australia as, and I quote, possibly the most secretive democracy in the world. Of these 875 provisions, 168 were identified as no longer warranting criminal liability at all. The review instead deemed that civil or administrative sanctions were more proportionate. The AGD review also recommended a new general secrecy offence to replace the sunsetting section 1.22.4 of the Criminal Code, which had long been the mechanism through which the non-disclosure duties across Commonwealth legislation attracted criminal liability. In 2024, the INSLM reviewed the general secrecy offences in Part 5.6. It found them uncertain, inconsistent with rule of law principles, and in some cases disproportionate, particularly as applied to non-officials such as journalists, lawyers, and human rights advocates. This bill gives legislative effect to both reviews. It repeals more than 300 secrecy provisions. It is nearly double the number recommended for repeal by the AGD review and a reduction of more than a third of Commonwealth secrecy positions. This is achieved primarily through the repeal of section 1.224 and targeted removal of criminal liability from non-disclosure duties across 13 portfolio areas. I am pleased to see this. The bill also introduces a new targeted secrecy offence directed at those who improperly use or communicate Commonwealth information to obtain a benefit or cause detriment. This narrow formulation responds to the PwC tax confidentiality breach, but does consciously reject the broader general offence proposed by the 2023 AGD review. In response to the INSLM's recommendation, the bill repeals the security classification limbs of the deemed harm offences, removing reliance on administrative classification markings as a criminal offence element. It repeals the dealing with offence for non-officials under section 122.4A2, ending the position where journalists face criminal liability merely for receiving sensitive information. It narrows deemed harm offences for officials, requiring a more direct connection to actual or likely harm. It nearly halves maximum penalties for non-official disclosure offences. It legislates a requirement that the Attorney-General's written consent be obtained before any journalist can be prosecuted for a secrecy offence. And it clarifies that unsolicited receipt and other unwitting dealings with information do not constitute dealing with for the purpose of Part 5.6. These are real reforms. They reduce criminal liability, raise thresholds and lower penalties. I do not want to diminish what this bill achieves. Reducing 875 secrecy provisions to fewer than 600 is a genuine accomplishment. Removing an absurdity of journalists facing prosecution for receiving unsolicited documents is a genuine improvement. But the genuine improvement is not the same as adequate protection. First, the new general secrecy offence does not adopt a harm-based approach. The replacement offence under the section 122.4 applies wherever a person improperly uses or communicates Commonwealth information with the intention to obtain a benefit or cause a detriment, terms defined in the Criminal Code Dictionary as an advantage or disadvantage whatsoever. But the Human Rights Law Centre and the Centre for Public Integrity note that this departs from what the AGD's own 2023 review recommended and from what the INSLM recommended. The concern is practical. Much ordinary engagement with government could theoretically involve some advantage to one party or disadvantage another. The HRLC gives the example of civil society organisations, including the very organisations who've submitted to the inquiry for this legislation, being provided with confidential draft legislation and asked to provide feedback. This is ordinary democratic participation. Whether or not it could fall within the offence's reach is, on the current drafting, at least arguable. The word improper provides some guard, but it is undefined. An undefined concept of impropriety is a thin protection in a provision that carries criminal liability. That is why I support the member for Curtin's amendment, which replaces the vague concept of improper communication with a concrete harm-based threshold. It limits criminal liability to communications that harm, or that the person intends or is reckless as to harming an essential public interest, such as national security, public health, or financial stability. It also explicitly protects journalism and whistleblowing that exposes wrongdoing. Second, the journalist defence remains structured against journalists. The defence in section 122.5, subsection 6, which protects public interest journalism, has not been amended. The Alliance for Journalist Freedom puts the position plainly. The current provision requires journalists to bear an evidential burden to establish they reasonably believed their conduct was in the public interest. That is contrary to the presumption of innocence. It is the journalist, not the Crown, who must raise and substantiate and prove the public interest claim, often in respect of conduct the journalist may not have known was covered by secrecy offence at the time. The HRLC and the Centre for Public Integrity and the AJF all identify this as an unimplemented reform. The INSLM's recommendation 13, which I note was agreed in principle by the government in November 2024, was that consideration be given to recasting the offence as an exception, shifting the burden to the prosecution. That recasting does not appear in this bill. That is deeply disappointing. Third, the Attorney-General's consent mechanism has structural limitations. I acknowledge this is an improvement on the current arrangement, but I hold concerns about its potential for politicisation. Journalists report on politicians. Whether a potential conflict of interest is real or simply perceived, the fact that a politician holds the power to authorise or block prosecution of a journalist for a secrecy offence is significant and should raise concern. As the HRLC noted in their submission, this mechanism is unsatisfactory as a matter of principle, though desirable in practice given the absence of stronger protections. It is disappointing that this must be our solution in the face of reforms which don't go quite far enough. And again, I support the member for Curtin's amendment requiring an independent review of this provision every 5 years in consultation with media stakeholders. Fourth, and following from this point, the bill has not come alongside necessary reform of the Public Interest Disclosure Act. We are still without a whistleblower protection authority. We are still without a single consolidated whistleblower act. A parliamentary committee first called for an independent protection body for whistleblowers in 1991. It was called again in 1994 and again in 2017. We are still waiting. This reform is monumental, but it does not appear in a vacuum in our legislation. It comes as David McBride is still in jail and as whistleblower advocates are still awaiting certainty. Currently, under section 122.5, subsection 4 of the Criminal Code, compliance with the Public Interest Disclosure Act can operate as a defence to a secrecy offence. But the PID's Act's requirement for qualifying external or emergency disclosure are highly technical. This makes it harder for whistleblowers to have certainty about whether disclosures which are well within public interest will leave them criminally liable. I'm moving a consideration in detail amendment to address this gap. My amendment would provide that where a whistleblower does not satisfy every technical requirement but can demonstrate that the disclosure was both reasonable and genuinely in the public interest, they may have access to additional certainty. These disclosures will still not be permitted to be given to a foreign public official. It doesn't resolve all the problems with our whistleblower framework, but it is a meaningful first step towards the protections that the public expects and whistleblowers deserve. This bill's Senate committee reports on the 19th of June. The government's response to those recommendations will be a test of whether its commitment to further reform is genuine. I commend the bill for inquiry and I urge the government to address these issues I have raised before its passage. Reducing this body of law from 875 provisions to fewer than 600 matters. Ending the absurdity of journalists being prosecuted for receiving documents matters. But we should not mistake progress for completion. The people this framework most affects, whether it be journalists, those who represent whistleblowers or civil society organisations, are still telling us it falls short. We should listen.
I call the Attorney-General.
Thank you, Madam Deputy Speaker. This bill delivers on the government's commitment to comprehensive secrecy reform. The objective of these reforms is clear: protect information that genuinely needs protecting while removing unnecessary barriers to transparency and public trust. The bill modernises Australia's secrecy laws by removing criminal liability from more than 300 secrecy provisions, ensuring criminal sanctions apply only where essential to protect genuinely sensitive information. It introduces a new targeted offence to address the improper use or communication of Commonwealth information to obtain benefit or causing detriment, closing gaps in the Commonwealth's secrecy framework and strengthens safeguards for press freedom. I note the member for Clark's second reading amendment. The Albanese government is delivering on our commitment to implement comprehensive reforms to Australia's public sector whistleblowing framework. That's why we commenced a public consultation process last year on exposure draft legislation on a second stage of reforms to the Public Interest Disclosure Act 2013. I thank all stakeholders who provided submissions as part of this consultation process. The government has been considering those submissions and will introduce legislation on the second stage of reforms. These reforms will build on the government's significant improvements to whistleblower laws implemented in 2023 and provide a comprehensive response to the 2016 independent review of the Public Interest Disclosure Act by Mr Philip Moss AM. This bill to reform secrecy laws and the government's considered and methodical approach to whistleblower reform are critical to supporting integrity and the rule of law. For these reasons, the government will be opposing the amendment. Australia's secrecy laws are essential. Without them, sensitive information could be exposed in ways that could damage public trust in government, cause real harm to our national security, or put lives at risk. But equally, transparency and accountability are vital features of our democracy. These comprehensive and considered reforms are about getting that balance right. I commend the bill to the House.
The question was that the bill now be read a second time. To this, the Honourable Member for Clark has moved an amendment that all words after that be omitted with a view to substituting other words. The immediate question is that the amendment be agreed to. All those in favour say aye. Aye. All those against say nay. No. I think the nays have it. As it is necessary to resolve this question to enable further questions to be considered in relation to this bill in accordance with Standing Order 195, the bill will be returned to the House for further consideration. I call the Clerk.
Government business, orders of the day number 4, Secrecy Provisions Amendment Sunsetting Provision Bill 2026, resumption of debate on the second reading.
The question is that this bill be now read a second time. There are no speakers for this bill. The question is that the bill be now read a second time. All those in favour say aye. All those against say nay. The ayes have it. I call the Clerk.
Second reading, a bill for an act to amend the Criminal Code Act 1995 and for related purposes.
If no member wishes to consider the bill in detail, I will put the report question immediately. The question is that the bill be reported to the House without amendment. All those in favour say aye. All those against say nay. The ayes have it. I call the clerk.
Government business. Next order of the day. Defence Force Discipline Amendment, RCDVS Implementation and Related Measures Number 1, Bill 2026, resumption of debate on second reading.
I call the member for Griffith.
Thank you, Deputy Speaker. I want to start by recognising all who currently serve or have previously served in the Australian Defence Force. Veterans, their families, those who support them, the people who provide their care and those grieving lost loved ones. Their bravery and courage helped bring the Royal Commission into Defence and Veteran Suicide into being. Some talked about their own time in the military, others about the person they loved and lost. Some spoke of the systems they tried to use, the phone calls that they made, the concerns they raised, the times help should have arrived earlier, and the damage done when it didn't. To everyone who shared their story with the Royal Commission, I say to them, thank you. The evidence provided to the Royal Commission was deeply felt. It was painful and it was freely given with the hope that others will be safer, get better help and be treated with more respect. This bill is part of how we show courage with concrete action. And service isn't just done by the person in uniform, it is carried out by their families also. Before coming into this place, I worked with the children of Defence families, and it's work that has stayed with me. We naturally think of the person in uniform when we talk about service, but it's also carried at the kitchen table, in classrooms, in the playground, in the normal everyday life of a family. For children in Defence families, service can mean long goodbyes to a parent, changing schools and suburbs, leaving friends and having to get used to new life, sometimes multiple times. It brings pride, yes, but also worry to a young person, trying to understand a parent's stress, injury, trauma, or absence at a time when they may not have the words for it. I saw the strength in those families and how important it is for the support around them to be consistent, respectful, and to respond to their needs, because when one person serves, the entire family is impacted. I just want to take a moment to acknowledge those in my electorate of Griffith who are doing very important work with the veterans who served our country. In Griffith, we're fortunate to have Gallipoli Medical Research, whose work has been changing lives for 2 decades. Last year, Gallipoli Medical Research celebrated its 20th anniversary, and it was a real joy to be there to join with them for that milestone. It was a moment to not only recognise the research itself, but the people behind it, the clinicians, researchers, veterans, families, partners and supporters who have built an organisation grounded in service, care and evidence. There was a moment that will stay with me forever, the last time I had the privilege to visit the Gallipoli Medical Research Centre. As we walked through the building, we were quietly asked to pause and step aside. We didn't know why at first, and then we saw a flag-draped coffin being carried past. A veteran. A soldier who had served this nation with courage and conviction. The hallway fell silent and we stood united in our respect. And in that moment, I thought about the profound responsibility we all share to do everything in our power to safeguard the futures of those who safeguarded ours. I do want to thank everybody at the Gallipoli Medical Research for the work they do each day to improve the health and wellbeing of veterans, service personnel and their families. I also want to acknowledge Legacy for their extraordinary care they provide to families connected to service. For generations, Legacy has stood beside partners, children and families carrying grief, loss and uncertainty after a loved one's service. Their work is practical, compassionate and deeply human, from social connection and advocacy to support for young people, helping families feel less alone when life has changed in ways they never expected. Deputy Speaker, just a couple of weeks ago, I was able to visit another service in my community, Mindful Mates Social Services, and its founder, Josh. He's passionate about building mental fitness for veterans, and there are so many other individuals in my community who are doing this really important work. Through these experiences and through my past work in the mental health sector, I know that mental wellbeing isn't just about what happens inside a person. It's also shaped by what support systems are around them. A clear, understandable process can lessen someone's distress. A safe work environment can encourage people to get help sooner. A system that actually listens can help someone feel less on their own. But the reverse is also true. Delays, confusion, people being ashamed to ask for help, and silence can all make things worse. Someone already vulnerable can be pushed even further into crisis if they feel stuck in a system that doesn't hear them, defend them, or treat them fairly. That is why the Royal Commission's conclusions about military justice are so vital. The Royal Commission showed that people in the ADF who have been involved with the military justice system are more likely to attempt suicide. And it was very clear that a properly working military justice system is essential not only for the good order and running of the Defence Force, but also for the mental health and well-being of those who serve. That's a significant point. It shows us that justice, discipline and looking after people's well-being can't be viewed as separate things. A victim of a crime needs to be protected, informed and supported. Someone accused of a crime needs to be treated fairly, have a clear understanding of the process, and to not have that drag on and on. And if mental health is a factor, the system must have the skills and understanding to respond with care. This bill helps move the military justice system in that direction. This Defence Force Discipline Amendment Bill puts into action important recommendations from the Royal Commission relating to military justice, specifically recommendations 18, 20, 23, 34 and 63. In effect, the bill aims to bring the military discipline system up to date. It makes sure victims are better protected, especially those of sexual and violent attacks. It creates better mental health support for people going through military discipline processes. It makes the process simpler, fairer and faster. It increases openness, and it brings parts of the military justice system more in line with the standards Australians expect from other courts. This bill prioritises protecting victims and making workplaces within the Defence Force safer, particularly when investigations into sexual misconduct or serious crimes are happening. The Royal Commission's entire 6th volume dealt with sexual violence in the military, unacceptable behaviour and military justice, and it's something we should all be deeply concerned about. No one should ever feel unsafe at work or be made to continue working with someone being investigated if it puts their safety or well-being at risk. I would like to take this opportunity to acknowledge a particularly fierce advocate in my community for our veterans, in particular women veterans and women who serve in our Defence Forces, Julia Delaforce. I am incredibly appreciative to Julia for all of her ongoing work in this space, standing up for the rights of our female soldiers and veterans. The bill makes it easier to suspend Defence Force members and now includes situations where someone is under criminal investigation by the police, not just the Defence Force itself, and where workplace safety could be jeopardised. This is a sensible and kind change. Safety doesn't have to wait for charges to be filed, and Defence, like any employer, needs to act when there is a risk of harm. Sentencing for serious violence and sexual offences will also be improved. Tribunals will have to think about the effect on victims, and the difference in rank between the person committing the offence and the victim will be recognised as important. This is especially vital in the military, where rank is a key part of daily life, and abusing that power can be incredibly damaging. Accountability is also being improved. Some convictions within the Defence Force will now be included in a person's criminal record when they deal with the civilian police. Serious wrongdoing shouldn't just disappear within the Defence Force's internal procedures. Victims need to feel the system isn't downplaying what happened to them, and the public generally have a right to transparency. The bill also introduces a disciplinary issue, a service offence, for harassment and a related breach of rules and regulations. This gives commanders clearer ways to deal with unacceptable behaviour and reinforces the standards expected across the entire ADF. Changing culture isn't just about new laws, but laws can set expectations, give leaders more responsibility and make it harder to excuse, ignore or cover up bad behaviour. A defence force where people are treated with respect isn't a bonus, it's absolutely essential for safety, trust and the defence force being able to do its job. People perform best when they feel valued, are more likely to get help early if they'll be treated well, and have more faith in the system if they see harmful behaviour having consequences. Important changes are also being made to how mental health is handled within the Defence Force's disciplinary system. A Defence Mental Health Tribunal framework is being established, and courts, martial, Defence Force magistrates, review bodies and appeal courts will have clearer ways to order mental health assessments. This is a significant step forward, acknowledging that mental health problems require specialist, structured and compassionate care. If someone is too mentally unwell to enter a plea or to be held responsible for their actions, the system should have a proper route to providing care, treatment, responsible or possible detention or release with appropriate protection for everyone. This isn't about letting people off the hook, it's about ensuring accountability is combined with fairness, a good understanding of the clinical issues and public safety. The language in Defence Force Discipline Act is also being updated too, including the offence of malingering. Language we know, Deputy Speaker, can make stigma worse or reduce it, and in mental health this is absolutely vitally important. In the Defence Force, where people are already reluctant to seek help because of rank, the culture and fears about how it will affect their career, it's even more important. Recommendation 63 of the Royal Commission endorsed reducing stigma and getting rid of barriers to getting help, and this bill contributes to that. Deputy Speaker, the bill also makes the military discipline system more efficient. This might seem like a technical detail, but it will have a real impact on people. When a case drags on, everybody suffers. Victims are kept waiting, those accused are in limbo, families are stressed, commanders are less clear about what's happening, and people lose faith in the system. This bill creates a new system for summary contraventions, less serious offences as a middle ground in the discipline system. Finally, this bill puts right a shameful injustice. Defence personnel were punished for a long time for having consensual same-sex relations. Some were charged and convicted under Defence Force laws for something that should never have been a crime. These convictions did lasting damage to people's careers, records, reputations, relationships and families, and caused unnecessary shame. This bill allows people to apply to have these convictions removed if the activity was consensual and wouldn't be a crime if it happened between a man and a woman. People with a close connection to the case, including the families of veterans who have died, can also apply. If a conviction is removed, it will be taken off all Defence Force records and the person won't have to disclose it. Others will be prevented from disclosing it without permission. This won't erase the pain caused by this past discrimination, but it can reduce ongoing legal and personal problems. It can give back dignity to records that should never have been marked like that. It's telling those veterans and their families that their service is valued, their dignity is important, and their record should never have been tainted by prejudice. Deputy Speaker, these reforms go to the real human consequences of a system that must be safer, fairer, and more responsive. It gives victims stronger safety measures, makes it easier to get mental health help, speeds things up and simplifies them, encourages openness and responsibility, and puts right something wrong from the past. It will help create a military justice system which is more in line with the principles we expect of our Defence Force personnel: dedication, consideration for others, bravery, honesty, and looking out for one another. We need to continue this improvement for all who are serving, all those who have served, and their families who share in the burdens of service. Deputy Speaker, there is still so much more work for us to do in this space, but I am so proud of these changes and what they will address. I do absolutely acknowledge the hard work that is happening throughout Australia, in particular in my community, and for all of those who have been advocating for these changes and changes beyond this, I absolutely acknowledge their passion, their persistence, and their absolute fierce advocacy on these matters, and I thank them very sincerely.
I call the member for Riverina.
Thank you, Deputy Speaker. And as I rise to address the Defence Force Discipline Amendment, Royal Commission into Defence and Veteran Suicide Implementation and Related Measures number 1 Bill 2026, I just want to note the attendance in the Federation Chamber of Departmental and Australian Defence Force personnel, and want to thank them for talking me through aspects of this bill. It's the DVA is an organisation which does provide so much assistance to our veterans, and sometimes is criticised unfairly, but I would urge and encourage veterans who need support to reach out to the DVA. It is always there. It is always absolutely wanting to provide the best care and support available to our wonderful veterans, and I thank the members in the chamber today for their presence. I also want to acknowledge the work being played locally in my Riverina electorate, in my hometown of Wagga Wagga, which is a tri-service city. We have the Blamey Barracks, home of the soldier, 1st Recruit Training Battalion at Kapuka. We have air power starts at Wagga Wagga, at Forest Hill, RAF Wagga, and at that particular base we also have 80 or so Royal Australian Navy personnel. So we've got Army, Air Force and Navy in town. And the Riverina Veteran and Family Hub, RSL Life Care at 240 Baylor Street, plays a vital role for our veterans, as does Pro Patria at 19 Moorshead Street, Ashmont. And for veterans seeking assistance, seeking to even get their head around the 122 recommendations in the Royal Commission, I urge and encourage them to avail themselves of those wellness centres, of those veterans hubs. And I thank and commend the people who run those two facilities. I also thank and commend anybody who has worn a uniform, anybody who is wearing a uniform now, and encourage anyone who intends to wear a uniform in the future, because our military plays such an important part. We all would have observed that on April 25, Anzac Day, our nation's most important day, and certainly the 103,000 names on the Roll of Honour at the Australian War Memorial bear testimony to the service and sacrifice of so many. The Australian way of life we enjoy today has been secured through the enduring service, the courage and the sacrifice of the men and women who have defended our nation in uniform. In times of natural disaster, peacekeeping, service and armed conflict, members of the ADF have consistently served with professionalism and distinction. In doing so, they've provided essential support to communities in need, contributed to international security and upheld this nation's responsibilities abroad and, of course, at home. Accordingly, in recognition of their service and sacrifice, it's incumbent upon us to ensure that Defence members and veterans are treated with the dignity, the respect and the appropriate support as provided by the Riverina Veteran Family Hub, as provided by Pro Patria, as provided also in Parker Street, Cootamundra. They've got a wellness centre there, and I pay tribute to the late Jackie Vincent, who has only just recently passed, for her almost 40 years of service to providing care and love for veterans in and around Cootamundra and elsewhere. This bill implements recommendations of the Royal Commission, a Royal Commission that was established by the former coalition government in 2021. It was necessary. The Royal Commission was established after the coalition listened to community calls for a national inquiry focused on the systemic issues faced by Defence members and veterans that can result in suicide. And the suicide statistics are awful reading. Between 1 January 1985 and the end of 2021, there were 2,007 confirmed suicide deaths of individuals who had served at least one day in the ADF since New Year's Day 1985. And those are terrible statistics, damning statistics, and so tragic. One death is one too many. One suicide is just tragic for the community, for the family, and for the the defence family at large. When the Coalition established the Royal Commission, we said its aim was to shed a light on the critical steps needed so we could reduce the heartbreaking cases of suicide. The Commission confirmed what veterans and their families in the ex-service community had been saying for so long, and they deserve truth, accountability and reform. We've also an obligation to our Defence Force and veteran community to ensure the issues identified by the Royal Commission are acknowledged and the necessary action taken. Now, the men and women of the Defence Force serve our nation with honour and bravery. They deserve the very best treatment, care and support. Now, the Royal Commission, as I say, engage with key advocacy groups to understand the impacts of service and including the families of Veterans Guild, Australian Peacekeeper and Peacemaker Veterans Association and the Australian Federation of Totally and Permanently Incapacitated Ex-Servicemen and Women. And I know that there's a lot of bipartisan support, incredible bipartisan support for anything to do with our veterans. And I do acknowledge that. As the Shadow Minister for Veterans Affairs, I appreciate the work that the government is doing to help and support our veterans. The Coalition acknowledges that this bill provides the necessary framework to implement recommendations 18, 20, 23, 34 and 63 of the Royal Commission. Our military justice system is the integral framework which underpins discipline in the military and command. The Coalition appreciates that delays in resolving violations of military discipline adversely affects the morale, the welfare and the operational effectiveness of the ADF. Prolonged uncertainty undermines confidence, it places strain on serving personnel, and this can have an effect on unit cohesion, on unit trust and command authority. Unresolved disciplinary matters may also have implications for the safety and well-being of defence personnel and the defence community, as well as obviously their families. It's especially so when misconduct is serious in nature or has an impact on operational environments. A fair, effective and timely military system is essential in protecting personnel, in maintaining discipline and ensuring that the Defence Force remains, as it always is, capable, professional and mission ready. Our servicemen and women deserve nothing less. The Coalition has a long history of actively reforming military discipline in Australia. The former Coalition government introduced reforms to update, to modernise the Defence Force Discipline Act, streamlining the handling of minor disciplinary matters and strengthening Defence's response to cyberbullying. And this is a worrying, growing and disturbing incidents. This sends also a clear message that bullying, harassment and unacceptable behaviour have no place within the Australian Defence Force. A strong, fair and effective military justice system is vital to maintaining fairness, discipline and operational effectiveness and confidence in our ADF. Now, going through the bill, it, as I said, implements key recommendations from the Royal Commission. Schedule 1 directly implements the Royal Commission's recommendations 18, 20, 23 and 63. Part 1, Schedule 1, introduces amendments to implement recommendation 18 of the Royal Commission's final report, which call for enhanced safeguards ensuring alleged victims are not required to work alongside alleged perpetrators whilst investigations are underway. The bill resolves this inconsistency by inserting a new subsection 98(2), introducing a new suspension power where a member is under investigation for a civil court offence by a Commonwealth, state or territory or overseas authority. The power aligns with the existing suspension authority under the Defence Force Discipline Act of 1982 for service offence investigations, ensuring a consistent and coherent framework across service, civilian and overseas contexts. These amendments seek to establish a clear and consistent mechanism to enable the suspension of Defence Force members whilst under investigation. Under current arrangements, a Defence member suspected of committing a service offence may be suspended whilst a disciplinary investigation is underway. Where a member is suspected of civilian criminal offence, including serious offences, suspension is not available until a formal charge has been laid. as civilian criminal offences are usually investigated by civilian authorities and not service police, this can create some inconsistencies and some unsuitable outcomes where members may be suspended for minor service-related matters, yet for more serious criminal allegations such as rape or murder until after charging. And our recommendation 18 only focused on sexual misconduct, but this suspension power is not limited to only those offences. The new suspension power is to apply to investigations which begin on or after the commencement of this part, as well as investigations already underway at that time. And suspension decisions remain subject to existing review mechanisms. Part 2 of Schedule 1 implements Recommendation 20, the Royal Commission, calling for service tribunals to take into account victim impact in sexual offence cases and to regard an offender's higher rank as an aggravating factor in sentencing. It gives effect, Schedule 2, to Royal Commission Recommendation 34, which required the priority review of provisions related to court-martial panels not being required to give reasons for punishments imposed. The schedule introduces a requirement for any conviction and sentencing decision by superior tribunals or reviews to be accompanied by reasons. We've got Schedule 3, Part 1, overhauling how the Defence Force Discipline Act deals with accused persons suffering from mental impairment by introducing new powers to allow the dismissal of a charge where the accused suffers from a mental impairment and prosecution would not meaningfully serve the maintenance of discipline. Schedule 4 introduces measures to streamline the military discipline system, reducing delays, broadening access to elections to a superior tribunal, and ensuring that minor disciplinary matters are dealt with expeditiously. Schedule 5 contains 16 parts dealing with a range of other amendments, including updating evidentiary rules, aligning the grounds for termination of judicial officers, strengthening review processes, modernising the powers of investigating officers, and introducing removal orders for intimate images. They also enable the provision of evidence by video link, providing for victim impact statements and allowing for the extinguishment of historical homosexual service convictions that would not be offences today. Schedule 6 establishes a transitional rulemaking power to provide for the transition between the existing discipline system and the new legislative framework. This rulemaking power is necessary. It deals with unintended outcomes or unforeseen issues arising from the transition from the old DFDA to the new DFDA. This schedule permits the Minister by legislative instrument to make rules prescribing matters required or permitted by the DFDA or necessary or convenient for carrying out, giving effect to the Act. And I do applaud that, because I think for far too long we've seen some powers taken away from the Minister. I do always think that ministers need to have the power to make these sorts of rulings, to make these sorts of provisions, and not always necessarily just go along with what the bureaucrats down the hill tell them to do. I've always been insistent on that, because I think at the end of the day the buck stops with the Minister. The Minister's going to be the one who has her or his name on the ballot paper, not the public servant, not the bureaucrat. I appreciate they do a fine job, but at the end of the day the Minister has to be responsible, because they'll be the ones who are answering the Parliament. They'll be the ones answering in question time questions related to these and other matters. I do worry that as part of the budget in the Attorney General's portfolio, additional resourcing, budget paper number 2, page 43 last night, and I quote, $50.4 million in 2026-27 to continue the work of the Office of the Special Investigator to investigate and support the prosecution of war crimes alleged to have been committed by the Australian Defence Force in Afghanistan. I do think that some of these provisions are sometimes going to these unnecessary witch hunts, if they prove to be that, are going to place unnecessary and undue stress upon our veterans. Our veterans served us well in Afghanistan. They did a lot of good work, particularly in giving women and girls opportunities that they would never have been able to avail themselves under the old Taliban regime, and sadly the new Taliban regime as well. And I think we should acknowledge and recognise the efforts that they went to, the service and sacrifice that they gave, and the more than 40 soldiers who lost their lives. And we say, lest we forget, and I think we should absolutely mean that. It's all well and good to go out on Anzac Day and commemorate, but we also should remember the constant pressure that those veterans will always be under for the rest of their lives for the service in Afghanistan that they gave.
Thank you. The member for Blair.
Thank you, Deputy Speaker. I'm very pleased to speak on this bill that relates to Defence Force discipline and the implementation related measures number 1 bill. Deputy Speaker, there are a few areas of governance where the Morrison government did worse than in Veterans Affairs and Defence personnel. Now, I don't believe for a minute it was through iniquity. I think it was just plain incompetence. Underfunding, outsourcing of the department responsible, the labour hiring, far few people on the front line with claims processing, waiting times, backlog of claims. These were words used all the times in the department and amongst the veterans community. Imagine, Deputy Speaker, a Minister for Veterans Affairs and Defence personnel threatening to resign on the eve of the budget because of the incompetence and underfunding of his own department by his own government. And that's what the member for Clare did and offered and threatened when he was not on the crossbench, when he was the actual responsible minister. Now, we had to rebuild the department, 500 frontline personnel processing claims, promising, and when we came to government, funding hundreds of millions of dollars towards this process, rebuilding the department. Why? Because all of this contributed to the tragedy of mental health problems, depression, suicidal ideation, and indeed suicide. The Australian Institute of Health and Welfare has said from 1997 to 2023, 1,840 ADF and ex-serving men and women died by suicide. That's 1,840 too many. Now, this bill implements and responds to the recommendations of the Royal Commission in part. This bill represents one of the most significant reforms to the Australian military justice system in decades and delivers on those recommendations. And it comes on top of lots of work done by the current Labor government. The Royal Commission came about and the Morrison government was dragged kicking and screaming by the grieving mothers and families of people who died by suicide. Whether it was coronial inquests, the findings of those coronial inquests, anecdotal evidence or personal experience, it was obvious that we needed a Royal Commission. Labor called for it and pushed hard in opposition. Certainly when I was the Shadow Minister we did. The reforms contained in this bill are comprehensive and collectively modernise our system. It's all about protecting people and it's all about also aligning with Australia's community expectations and contemporary expectations in terms of social issues. The bill, as I said, has its genesis in the recommendations, and it's worth remembering that the Coalition did everything they possibly could to avoid a Royal Commission. They announced even a half-baked National Commissioner for Defence and Veteran Suicide Prevention, claiming it was bigger and better than a Royal Commission. It was simply a marketing exercise to placate the grieving families and block their demands for a proper and independent investigation into these tragic deaths. With only a backbench revolt and the pressure of Labor and the extraordinary campaign by brave mothers like Julianne Finney, Karen Bird and Nikki Jamieson, who all tragically lost their sons to suicide, together with so many other people that the Morrison government was forced into this Royal Commission. So we have a 100-year opportunity to fix our broken veteran support system. The Royal Commission did a mighty job and I want to commend the commissioners for it. Delivered their final report in September 2024 and made 122 recommendations, and we've accepted overwhelmingly the majority of those recommendations, agreeing in principle to 104 recommendations. We've been working to implement these as quickly as possible, and I want to commend the Minister for Veterans Affairs and Defence Personnel for his strong response in implementing those recommendations. Now, the Royal Commission dedicated a whole volume to sexual violence and unacceptable behaviour in military justice. The legislation before us today makes a significant step towards implementing those recommendations. It responds to concerns about fairness, transparency, mental health treatment, timeliness and complexity within the Defence Force Discipline Act of 1982. The reforms contain, as I say, about modernising the system, and they are very, very important. The bill directly implements recommendations 18, 20, 23 and 63 and gives effect to recommendation 34. Now, these are about strengthening workplace protections during sexual misconduct investigations, sentencing and recording of convictions for perpetrators of military sexual violence and court-martial governance. The Royal Commission noted that involvement in the military justice system, whether as a victim or as an accused, can itself be a factor for suicide. It highlighted the pressing need for improving workplace protections, modernising sentencing practices, reporting and recording serious offences, consistent with civilian jurisdictions, and a more modern management in terms of mental impairment in disciplinary proceedings. Nearly 34 years ago, in November 1992, Prime Minister Paul Keating declared homosexual men and women would no longer be banned from serving in the Australian Defence Force. These changes will allow defence personnel who are convicted of offences purely on the basis of consensual homosexual activity to apply to have this conviction extinguished. The effect of this extinguishment will be to prevent disclosure of that conviction or information relating to it by other people. Family of defence members, including of deceased veterans, can apply under this scheme on behalf of their loved ones. These changes are overdue restorative legal change to help lessen the detriment associated and the stigma imposed by former homophobic attitudes and practices reflected in such convictions. We should be always proud of those who serve our nation regardless of their sexual identity and proclivities. With these changes to enable expungement of convictions now, this will no longer be a crime. Those who had previously had to hide can have their pride, and I use that word deliberately, pride in their service accurately reflect their service record as well. Additionally, the bill amends the offence of malingering to remove stigmatised and pejorative language and provide for the reporting of certain service offences for inclusion in civilian criminal history records. At its heart, the bill amends the Defence Force Discipline Act by making amendments which implement these recommendations. They're about enhancing the treatment of members engaged in the discipline system by modernising mental health provisions. We have changed enormously in terms of our understanding of mental health in the last generation. The Royal Commission found that Defence Force members with underlying mental health issues may be more likely to be involved with the military justice system, and that such involvement is a risk factor for suicide. How we didn't know that? We knew that in the civilian and criminal justice systems in our country, and it took us to the Royal Commission for this to come to light. This was always the case in our criminal and civilian systems, in our courts. Always the case. The overall effect of these measures is to give effect to necessary reforms to improve health and wellbeing outcomes for both victims and accused defence members and reduce the risk of suicide and suicidality. Before imposing any punishment, a member's rank and the seriousness of their disciplinary contravention or offence must be considered. Generally, the higher the rank, the more serious the consequence for contravention. The Royal Commission stated, and I think it's really worth quoting, a well-functioning military justice system is essential for defence to maintain good order and effective operational control. It's a defence matter. It really is a defence capability and national security issue. And the Royal Commission went on to say this: it is equally crucial to the mental health and well-being of Australian Defence Force members. This bill also allows the Minister for Defence to issue guidelines to the Director of Military Prosecutions, and the approach aligns with Section 8 of the Director of Public Prosecutions Act 1983, a similar power to the Attorney General to issue directions and guidelines to the Commonwealth Director of Public Prosecutions. It seems extraordinary that we have to do this now. It should have always been there. The bill implements a number of other reform recommendations, including stronger protections over disclosure of sensitive material during discipline investigations. It implements a whole range of recommendations in that space. I want to make it clear on this side, we condemn sexual abuse and harassment in the workplace wherever it occurs. When Labor called for a Royal Commission into Defence and Veterans Suicide and Opposition, and when the former government finally announced one, we called for it to cover the issue of abuse of female defence personnel. So it was pleasing the Royal Commission made a number of recommendations in this area, and we are grateful for it. Make no mistake, we're committed to addressing sexual misconduct and discrimination in the ADF and ensuring that members who have experienced mistreatment during their service receive all the support they need. It was the former Labor government under Kevin Rudd and Julia Gillard that initiated the Defence Abuse Response Task Force in response to sexual misconduct within the ADF. As a result of this report, the Defence Force Ombudsman's role was expanded to include an abuse reporting function. It was that former Labor government that undertook a review of the by the Sexual Discrimination Commission, which led to the establishment of the ADF's Sexual Misconduct Prevention and Response Office. So we have a proud record in this space of taking action during the years of Kevin Rudd and Julia Gillard. Finally, I want to add that last night's budget highlighted a number of really important things that the Albanese Labor government is doing in terms of making historic investments in defence personnel and veterans. We continue to deliver on the government's response and an allocation of $770 million in additional funding to deliver on the Royal Commission's recommendations. And this includes $169.7 million in funding for 5 years to increase fees for allied health providers from the 1st of July 2027 and the largest investment in allied health fees for veterans in over 20 years. The budget provides $29.8 million to support the establishment of a national veterans data asset and $16.6 million for Defence and Veterans Service Commission to conduct an independent inquiry into military sexual violence in the ADF from the middle of 2026. This all goes to show the Albanese government is committed to delivering for current and former ADF personnel and their families. I know this from my own electorate, and I'm very proud to secure $5.4 million commitment at the 2022 federal election for a new Ipswich veteran and family hub. This is part of the Albanese government's $46.7 million commitment to establish 8 new veterans and families hubs across the country to ensure that more veterans and families can access support closer to home. Now, that hub, which is nearly ready to be opened, will be operated by the RSL Queensland and co-located with Mates for Mates Centre in West Ipswich. It was great to have the Minister for Veterans Affairs and Defence Personnel come to announce the final location in August last year. Importantly, the facility is being co-designed with veterans and families to ensure support and social connection that lines up with the needs of the local veterans community, and will liaise with local sub-branches and wounded heroes who do a mighty work in crisis support in our local area and nationally. We have more than 10,000 veterans and families living in Ipswich and the surrounding area, in addition to 5,000 and more ADF personnel stationed at RAF Base Amberley. The Ipswich Veterans and Family Hub will provide tailored mental health and wellbeing services. And just like in this bill, it's all part of the Albanese government's urgent focus on responding to the recommendations of the Royal Commission into defence and veterans suicide. In conclusion, Deputy Speaker, the reforms in this bill strengthen trust in the military justice system, they reduce harm, they improve transparency, they modernise mental health responses and ensure the Defence Force Discipline Act reflects the standard expected in contemporary Australia. And I thank the Minister for bringing forward these critical reforms. I want to thank the many stakeholders, experts and the ADF personnel and Veterans Committee for their input into these reforms, and the Royal Commissioner. And in many cases, the brave victim survivors of abuse in the ADF for courageously sharing their lived experiences to inform these changes. This is a careful, comprehensive and essential response to the findings of the Royal Commission. It supports the wellbeing of our defence personnel, it strengthens the integrity of the military disciplinary framework and upholds our expectations of fairness and accountability. And I commend the bill to the House.
Oh, thank you. The question is that the bill be now read a second time, and I call the member for Bradfield.
Thank you. A few weeks ago, like many members of this parliament, I attended Anzac Day services across my community, and I felt deeply honoured to attend these events. Each gathering was a moving tribute, from the dawn service in West Pymble to the early morning in Turramurra, both hosted by our wonderful local Scouts groups, right through to the Willoughby Family and Community Service that was led by the Chatswood RSL and Willoughby Legion and the Lions Club service in St Ives. These ceremonies, they bring together our community in shared remembrance, and there's an opportunity to reflect on the bravery and sacrifice of servicemen and women, their stories brought vividly to life by thoughtful speakers who honoured their spirit of mateship and everyday humanism set against the profound realities of war. These community events remind us that Anzac Day is not only about history, it's about the concrete service and sacrifice of people in our communities and their families that support them. When the last census was taken in 2021, there were over 2,000 veterans in my electorate, and many of these servicemen and women were at these ceremonies across the North Shore last month. Anzac Day is a reminder that we have a responsibility not just to recognise our veterans at least once a year, but to ensure that they are properly recognised in our laws, in our institutions and our society, even after the last post fades. But too often we fail in that respect. The bill before us today reflects that failure insofar as it stems from the work of the Royal Commission into Defence and Veteran Suicide, a commission that was initiated because of the hardship faced by veterans across the country. But at the same time, the bill represents a step forward, however incremental, towards achieving better outcomes for those veterans. And it's for this reason that I welcome and commend the Defence Force Discipline Amendment Bill of 2026. The bill makes progress by putting into legislation a number of recommendations of the Royal Commission. The Commission was established in 2021 after years of advocacy by veterans and their families and delivered its final report in 2024. It was unprecedented in terms of scope and devastating in what it revealed about the human cost of systemic failure. It rigorously examined systemic issues in defence, veteran services and military culture, and heard evidence from thousands of serving members, veterans, families and experts. This testimony was often given at enormous personal and emotional cost, reliving trauma and loss because they believed telling the truth would lead to lasting change. A few months ago, I met with a veteran from my community who had participated in the Royal Commission process. And along with his mother, he shared his painful story with me, describing how after his career spiralled after he disclosed his PTSD to his commanding officer. And rather than support him, his command challenged and disrespected his medical diagnosis, isolating him from his colleagues and his friends, and failed to assist him in finding useful employment outside active service. Look, it's experiences such as these that have created the widespread sense of mistrust among the veteran community about the institutions that are there supposed to be supporting them. And my constituents explain how, after years of poor leadership, opaque processes and inconsistent decision-making, how that has taken a toll on veterans and their families. These systemic issues have long-lasting effects on veterans, destabilising careers and damaging mental health well after a return to civilian life. But too often there is little accountability for these impositions of authority. Above all, my constituents emphasise that veterans are not seeking special recognition, just dignity, just respect and fair treatment. Their key message to me was to not let the momentum of the Royal Commission slip away, but to ensure its recommendations progress into practical, transparent and accountable implementation. The Commission demonstrated that suicide and suicidality amongst Defence members and veterans is not a result of individual weaknesses, but of systemic failure, and that preventing future harm requires sustained, comprehensive reform. To guide that reform, the Commission made 122 recommendations in its final report, of which the government has agreed to 104. This bill seeks to implement 5 of them, focusing primarily on the military justice system. And this is necessary reform, with the justice system identified by the Royal Commission as frequently compounding distress and elevating suicide risk rather than alleviating it. Now, among the reforms introduced here are strengthened workplace protections during sexual misconduct investigations, amended sentencing procedures for serious, violent or sexual offences and disclosures of service offences, and enhanced options to address mental health conditions within the military discipline system. The bill also streamlines tribunal procedures, for instance by requiring reasons for punishments to strengthen sentencing transparency. And really importantly, it removes outdated and stigmatised language from legislation, aligning terminology more closely with modern usage and understanding. All these reforms matter, and taken together, they represent a really meaningful step in the right direction. But we must be honest with ourselves and with the veteran community. This bill responds just to 5 recommendations of the Royal Commission. There remain many, many more yet to be implemented. And the Royal Commission was clear. Suicide prevention in defence and veteran communities requires comprehensive and sustained reform. Families, including ageing parents and children who have lost a parent physically or mentally, continue to live with those consequences every day. Its recommendations were not abstract policy suggestions. They were a national undertaking, a promise that Australia would do better by those who served our nation, in some cases paid the ultimate price for our freedoms. And that means implementing all of the recommendations, not only those that are administratively convenient or legislatively straightforward, but those that require deeper cultural change, genuine independence of oversight, and real accountability for leadership failure. The ongoing work of the newly established Defence and Veterans Services Commission is critical in that respect. And just last week, the Acting Commissioner launched its independent inquiry into the progress on implementing the Royal Commission's recommendations. And that report I'm looking forward to reviewing in February next year when it's delivered. But this responsibility, it stretches beyond the Commission. It stretches to all of us. We have all a responsibility to ensure that veterans who are already out of active service or given meaningful work inside the defence and veterans community, or if leaving the service altogether, that they are not forgotten, but can instead live with dignity and fairness. This bill is a welcome step forward. I support it, and I urge the government to continue its important work in this area with dedication and with focus. But the work will continue until the full intent of the Royal Commission is realised, until trust is rebuilt, and veterans and their families can be confident that our institutions serve them with the same loyalty and integrity that they showed in service to Australia. If we genuinely honour our veterans, we must honour that promise too.
I thank the member, and the question is that this bill now be read a second time, and I call the member for Spence.
Well, thank you, Acting Deputy Speaker. The Defence Force Discipline Amendment is one that speaks to national responsibility in the lived reality of those who serve, those who wear the uniform today, those who have worn the uniform, and the families who carry the burden of service alongside them. Because when Australians step forward to serve their country, there is an understanding, not written down, but deeply felt, that the nation will stand behind them in return for their service and/or sacrifice. That obligation matters most in difficult moments, when people are under pressure and relying on the systems around them to work as they should. It is reflected not simply in what we say about service, but in the practical support, protections and accountability we build into the institutions responsible for caring for those who serve. The Royal Commission into Defence and Veteran Suicide asked this country to confront some very hard truths. It asked us to listen carefully to the experiences of serving personnel, veterans and, importantly, their families. It showed that while service remains a great source of pride for many Australians,
For too many, it was accompanied by harm that should never have been allowed to occur. The Royal Commission also made clear that systems intended to support personnel and veterans could at times contribute to their distress, particularly when processes became overly complex, delayed or disconnected from the human impact they were having. In too many cases, those pressures left individuals feeling isolated, unheard and unsupported at the very moment they needed confidence in the institution around them. That is why this government called for the Royal Commission while in opposition. That is why we supported its work while in government. And that is why we are now focused on implementing its recommendations, not slowly, not reluctantly, but with purpose. On the 2nd of December 2024, the government delivered its formal response. Of the 122 recommendations put forward, we agreed in principle on to 104 and further 17 were noted for further work. By the end of 2025, 32 recommendations had already been implemented, and by the end of this year, around 2/3 of all recommendations are expected to be in place. That is progress. But we are not finished, and we're not at the finish line yet. This government is committed to delivering the Royal Commission response because those who have served our nation deserve more than words. They deserve action. In the budget announced last night, we committed to investing more than $770 million in additional funding to deliver on the recommendations of the Royal Commission and strengthen support for veterans and defence personnel across Australia. That includes $169.7 million investment over 5 years to increase fees for allied health providers from 1 July 2027, representing the single largest investment in allied health fees for veterans in more than 2 decades. We're also investing $29.8 million to support the establishment of a national veterans data asset, helping ensure governments can better understand the experiences of veterans and deliver services that meet their needs. In addition, this budget provides $16.6 million for the Defence and Veterans Service Commission to conduct an independent inquiry into military sexual violence in the Australian Defence Force from the middle of 2026. These investments are about accountability, reform and making sure that those who have served our country are treated with the respect, care and support they have earned. The legislation before the House also goes to one of the most important parts of that reform task, the military justice system. Now, for many Australians, military justice might sound like a narrow or highly technical area of policy, but those serving within defence, its impact is far more significant and deeply personal. It influences how misconduct is addressed, whether victims have confidence to come forward, and whether personnel are treated fairly, shaping culture, standards and trust across defence. The Royal Commission made a very clear finding that involvement in the military justice system is associated with an increased risk of suicide. That is a sobering conclusion, because it makes clear that the structure and operation of the system itself can have a profound impact on the people moving through it. The length of time processes take, the way individuals are treated during those processes, the support available to them, the broader culture surrounding the system all play a role in shaping outcomes and influencing trust in the institution. This bill recognises that reality. It recognises that military discipline and mental health cannot be treated as separate conversations. It recognises that workplace safety cannot be an afterthought. And it recognises that fairness, efficiency and accountability must sit alongside one another, not in competition, but in balance. The Royal Commission dedicated significant attention to issues of sexual violence, unacceptable behaviour and the operation of military justice. It reflected the fact that these issues go to the core of whether defence is a safe and respectful workplace, because discipline on its own is not enough to build a strong and effective organisation. Trust between personnel matters, respect within the workplace matters, and creating an environment where people feel safe and supported matters just as much to the long-term strength and integrity of defence. And so too does a culture where misconduct is addressed properly, consistently and transparently, giving personnel confidence that standards are being upheld fairly across the organisation. This reform takes a significant step toward that goal. It modernises the Defence Force Discipline Act, which implements key recommendations of the Royal Commission. And it brings military justice closer to the standards Australians expect from contemporary systems of fairness and accountability. But more than that, it reflects a shift in approach, a shift away from seeing discipline as purely procedural and toward understanding it as part of a broader system that impacts wellbeing, culture and trust. One of the most important aspects of these measures is the strengthening of workplace protections, particularly in cases involving serious misconduct. Too often, individuals who raise concerns have found themselves continuing to operate in environments that feel unsafe. Too often, the burden has been placed on the person who reports harm, rather than on the system to respond effectively. That cannot continue. This bill expands the circumstances in which a person can be removed from the workplace. It allows action to be taken where a person is under civilian criminal investigation and where there is a risk to workplace safety. This is not about prejudging an outcome, it is about managing risk, and it is about protecting people. It is about ensuring that the workplace does not become another site of harm while processes unfold. The bill also deals with how serious offending is recorded and recognised. The Royal Commission identified the importance of ensuring that convictions for sexual and related offences are properly documented. Also established is a framework for mandatory disclosure of relevant convictions. And importantly, it aligns defence processes more closely with civilian expectations. Where appropriate, convictions will be reflected in civilian criminal history records. That is meaningful change, because accountability must be visible, consistent, and it must reflect the seriousness of the conduct, regardless of the system in which it is being dealt with. Also introduced is a specific disciplinary offence relating to harassment, and that it is an important step forward. Harassment is not a minor workplace issue that can be brushed aside or dealt with informally. It goes directly to the culture of an organisation and the safety of those within it. It can erode confidence, isolate individuals from their peers and leaders, and place sustained pressure on a person's mental health over time. Left unchecked, it does more than harm to the individual. It creates an environment where standards slip, where poor behaviour is normalised, and where more serious misconduct can take root. By giving Defence clearer tools to address harassment early and consistently, this bill reinforces expectations of respect, accountability and professionalism across the force. It reinforces the expectation that all members of Defence, regardless of rank or role, are held to the same standard of behaviour. That matters. And it supports the broader cultural change that the Royal Commission called for. Another important reform relates to the handling of sensitive material. People who come forward in cases involving sexual offending or other deeply personal matters must have confidence that their information will be treated with care. This reform strengthens protections around the disclosure of that material. It introduces the risk of unnecessary exposure, and it helps build trust in the system. Alongside that, the bill also allows the use of video evidence in sexual offence matters. That is consistent with modern practice in civilian courts. It recognises that the process of giving evidence can itself be traumatic, and it seeks to reduce that burden without compromising fairness. A critical part of this legislation is its focus on mental health within the discipline system. For too long, the mechanisms available have not reflected contemporary understanding of trauma, stress, and suicide risk. This bill introduces treatment pathways and diversionary options where appropriate. That does not mean misconduct is overlooked. It ensures the system is better equipped to respond to the individual circumstances of those before it, including recognising where mental health is a relevant factor and tailoring responses accordingly. Just as importantly, it helps guard against outcomes where the process itself compounds distress, ensuring the operation of the system reduces harm rather than inadvertently adding to it. By streamlining processes and reducing unnecessary complexity, the bill also helps shorten the time individuals spend within the system. That matters. Prolonged uncertainty can be deeply damaging, particularly for those already under strain, and delays only serve to compound that stress over time. A system that operates efficiently is not just administratively better, It is more humane and ultimately more likely to earn the trust of those who depend on it. These reforms operate across all levels of military discipline. They are designed to create a more consistent, modern and effective system, one that supports good order and discipline while giving commanders the clarity and authority to act appropriately. At the same time, it helps ensure resources are directed where they are needed most, towards serious matters, while aligning the operation of the system with the expectations of the community rightly holds of fairness, accountability and professionalism. Importantly, the bill also addresses an historical injustice. It provides a pathway for defence personnel who were convicted solely based on consensual homosexual activity to have those convictions extinguished. This is a significant measure because it acknowledges the past policies caused real harm. It acknowledges that people were punished not for wrongdoing but for who they were, and it provides a means to remove the ongoing impact of those convictions, including preventing their disclosure. It also allows families, including those of deceased veterans, to apply. That matters because the effects of those policies did not end with an individual. They extended to families, to reputations and to legacies. We know that this reform cannot undo the past, but it can help address its consequences. These legislative changes sit within a broader program of reform. Work is underway to further examine military sexual violence, including research into military sexual trauma and stronger responses and support for victims, because legislative change on its own is not enough to deliver the reform that is required. It must be accompanied by cultural change within institutions, by stronger accountability at every level, and by sustained attention to ensure those changes take hold over time. It strengthens protections for those at risk, improves accountability across the system, modernises processes that have not kept pace, and recognises the clear connection between justice, culture and mental health outcomes. This debate ultimately comes back to a simple question. Are we prepared to learn from what the Royal Commission has told us? Are we prepared to make the changes required? And are we prepared to ensure that future generations of defence personnel are better protected than those who came before them? These amendments answer those questions with a resounding yes. It does not claim to do everything, but it does take an important step forward. It reflects a commitment to fairness, a commitment to safety, and a commitment to ensuring that those who serve are supported by systems that are worthy of their service. To the veterans and families who shared their experiences, your voices have been heard. To those currently serving, your well-being matters. And to those we have lost, this Parliament has a responsibility to act. That responsibility continues, and today we take a step toward that meeting it. Thank you.
I thank the member and call the Minister for Veterans Affairs and Defence Personnel.
Thank you, Deputy Speaker. The bill before us today represents one of the most significant reforms to Australia's military discipline framework in decades, delivering on key recommendations from the Royal Commission into Defence and Veteran Suicide. The Royal Commission heard harrowing stories of sexual violence, unacceptable behaviour and military justice. The legislation before us today, the Defence Force Discipline Royal Commission into Defence and Veteran Suicide Implementation and Related Measures No. 1 Bill, takes a significant step towards implementing recommendations in that space. The bill responds to concerns about fairness, transparency, mental health treatment, timeliness and complexity within the Defence Force Discipline Act. Now, during the debate, the Shadow Minister raised a concern about the military police equipment measures in the bill. And so, to clarify, the bill creates a power for military policing equipment to be carried, handled and used for the purpose of a member's duty as a police member. This measure replaces the current requirement for individual state and territory agreements to be reached in respect of the suite of policing equipment that is used by military police, which mirrors the equipment that civilian police use to do their jobs. In particular, it will allow for the carriage and use of body-worn cameras while undertaking military police functions, and streamline the authorities currently required to store, maintain and carry other equipment, such as tasers. The basis for use of such weapons will not be changed by this measure. For example, The use of tasers will still only be lawful in circumstances of self-defence where other responses were not reasonably available. With this measure, if such circumstances arose, military police would have the benefit of a body-worn camera recording their use of the weapon. This is an efficiency and transparency measure which enables the use of the same equipment by military police across all jurisdictions that they operate in, with conditions and circumstances of carriage and use able to be limited through ministerial direction. Collectively, the reforms in this bill will modernise the military justice system so it protects people and simply it aligns with the expectations of the Australian community. Each measure in this bill brings the Defence Force Discipline Act in line with contemporary Australian law and practice. Things like providing for the extinguishment of historical homosexual service conviction records that would not be offences today. The extinguishment of historical homosexual service convictions is an important measure and step in righting a historical wrong. These changes will allow defence personnel who are convicted of offences purely on the basis of consensual homosexual activity to apply to have this conviction extinguished. These law reforms are a step towards healing, seeking to lessen the detriment associated and stigma imposed by former homophobic attitudes and practices. Additionally, the bill enables individuals who are suffering from mental impairment to be treated with respect and dignity whilst being dealt with appropriately under the discipline system. Importantly, the bill will establish a Defence Mental Health Tribunal framework, one of the most transformative parts of the bill. This tribunal will have the power to order treatment, care or detention when a person is unfit to plead or acquitted due to mental impairment. I thank members across the House for your contributions and for your support of the government's work so far to improve the lives of current and former serving personnel and in implementing the recommendations of the Royal Commission into Defence and Veteran Suicide. It's reforms like this that we've achieved together that will support the well-being of defence personnel, strengthens the integrity of the discipline system and upholds community expectations of fairness and accountability. I commend the bill to the House.
I thank the Minister. The question is that this bill be now read a second time. I put the question. All those in favour? Aye. Against? I think the ayes have it. I call the clerk. Okay.
Second reading. A bill for an act to amend the law relating to defence and for related purposes.
Thank the clerk. If no member wishes to consider the bill in detail, I will put the report question immediately. The question is that this bill be reported to the House without amendment. All those in favour say aye. Aye. Against? I think the ayes have it. I call a member for Braddon.
Thank you. Deputy Speaker, I ask leave of the Federation Chamber to move that Order of the Day number 5, Government Business, be postponed until a later hour this day.
I call the member for Nichols.
I second the motion.
I move that Order of the Day number 5, Government Business, be postponed until a later hour this day.
Yeah. Call the member for Nichols.
I second the motion.
Second. Thank you.
Thirded the motion.
The question is that the motion be agreed to. All of those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Call the clerk.
Government Business Order of the Day number 6. Resumption of debate on the condolence motion relating to the death of the Honourable Peter Frederick Morris OAM.
I call the member for Newcastle.
Thank you, Deputy Speaker. And it's a great honour to rise in this chamber this evening to pay tribute to the life and legacy of the Honourable Peter Morris. A principled Labor man, a reformer of conviction, and one of the most significant public figures our region has produced. Peter Morris dedicated more than 25 years of his life to public service, serving the people of the electorate of Shortland in this Parliament from 1972 to 1998. Across those decades, he became known not only as a highly capable minister and parliamentarian, but as a tireless advocate for the hunter and for working people right across Australia. His passing is deeply felt in Newcastle and throughout our region. Peter's story was shaped by the hunter from the very beginning. He was the son of a Greek migrant who came to Australia seeking opportunity and a better future for his family. And like so many migrant families who helped build our industrial regions like Newcastle, the Morris family understood hard work, resilience and community. Peter grew up with those values deeply ingrained in him. He attended Newcastle Boys High School and later built his career in local government before entering federal politics. Long before he came to this chamber, Peter had already developed the qualities that would define his public life: intelligence, determination, integrity, and a fierce commitment to the people he represented. And no matter how senior the office he held, Peter never lost sight of where he came from. He was always, unmistakably, a hunter local. He carried with him the instincts of someone who understood working communities, communities built around the steelworks, the mines, the railways and the waterfront. He understood the aspirations and anxieties of ordinary families because they were the communities that shaped him. Peter entered the Australian Parliament during a transformative period in Australian history, and he helped shape many of the reforms that modernised our nation. As a minister in the Hawke government, he played an important role in advancing major transport and infrastructure projects that would leave a lasting mark on both our region and Australia more broadly. Peter understood that transport and infrastructure was never just about roads, airports or transport corridors. For him, infrastructure opened up opportunities. It was about connecting communities, supporting jobs, driving investment and ensuring regions like ours were never left behind. His work supporting the development and growth of Newcastle Airport helped lay foundations for what has become one of the Hunter's most important economic assets. And today, Newcastle Airport stands as a critical gateway for tourism, defence, industry and trade, supporting thousands of jobs and helping connect our region to the world. And I would just add that true to his Labor values and principles, Peter ensured that Newcastle Airport was established with a model of ownership between the two local councils, so that today it remains the largest airport in Australia that remains in public ownership. Returning, the profits therefore then get returned to the communities that bought into that airport in the first place. So the City of Newcastle and the Port Stephens Council remain as custodians, leases of those lands, and those profits are returned. And it's a remarkable model. It is a remarkable model, and it was only somebody like Peter Morris who had the foresight to set it up in such a way that this airport would never be privatised and sold off, and that the communities that house the airport and that invest in the airport get to benefit from it as well. So I really, a lot of Novocastrians for many, many generations will be giving thanks to Peter Morris for his foresight in that regard. But that was just one example. Peter also understood the importance of better road connectivity between Newcastle and Sydney. It remains a sport for Novocastrians to sort of critique the transport corridors between these two cities. But Peter's advocacy around the M1 motorway corridor reflected his staunch belief that improving transport links would strengthen economic growth, improve safety and better connect regional communities to major cities and opportunities. And through his involvement in aviation and transport policy, including work connected to the now just opening new second airport of Sydney at Badgerys Creek, Peter helped shape national conversations about the future of Australian infrastructure and economic development. These were nation-building reforms and projects. But Peter never approached them in any abstract policy terms alone. He understood what these projects meant to working people. He understood what secure jobs meant to families trying to pay the mortgage, raise the children and build a future. He understood what investment meant to regional confidence, that practical understanding grounded his politics throughout his career. Peter also held a deep appreciation for Newcastle's rich maritime history and the communities built around our harbour and busy waterfront. He played an important role in the opening of the Newcastle Maritime Museum, helping ensure that the stories of our port, our working harbour, our seafarers and our industrial heritage were preserved for future generations. And that contribution reflected Peter's broader belief that Newcastle should always celebrate and honour the working people and industries that shaped our city. I welcome the current discussions with the New South Wales Government around getting the museum's collection back into public display so that the community can once again engage with this important part of our history. I know just how disappointed he was when that museum closed, and I know that it was his wishes that this would be a temporary closure. And so he was really heartened to know that there were people still fighting for the Maritime Museum in Newcastle. And I really want to take this moment to acknowledge the Newcastle branch of the Maritime Union of Australia for the very constructive role that they have played in those discussions and for their continued advocacy in preserving Newcastle's maritime heritage. It was certainly one of the most pleasurable last memories I have of being with Peter before he went into care was out on a restored restored vessel called William IV. And he was so proud. I mean, that boat now commemorates him. He was so thrilled to be out there on the water once again. He looked like the happiest man in Newcastle that day, and it's a great joy for me to be able to remember him in that context of in the place that he loves so much, on the William IV boat touring the working harbour that he dedicated much of his life and advocacy to. So it's a special memory that will stay with me, that's for sure. But Peter's most enduring and nationally significant contribution perhaps came through his fearless advocacy, not as a minister, not someone holding high office in this place, but at that time a humble backbencher heading up a committee. He wrote an extraordinary report that many of us today still continue to refer to. And I see the former Deputy Prime Minister, now member for Riverina, acknowledging that. It was indeed his landmark report, The Ships of Shame. And for those of us that have been around the block enough, we know just how important that report was. In 1992, Peter chaired the inquiry into shipping safety and standards that exposed shocking exploitation and dangerous practices occurring aboard foreign vessels operating in Australian waters. And that report uncovered, as I said, appalling conditions endured by seafarers, unsafe ships, inadequate living conditions, exploitation of crews and systemic neglect of safety standards. It was confronting. But Peter refused to look away, and at the time there were powerful interests content to ignore those conditions. Peter insisted that Australia had a responsibility to uphold fairness, dignity and safety for all workers. People visiting our shores were not somehow carved out of that in Peter's mind. And the Ships of Shame report became a catalyst for reform in maritime safety and regulation. It's a standard that is still used today. And I recall just a very recent, when I was speaking to the Newcastle branch secretary of the MUA, he made very clear to me that seafarers would still be working on rust buckets today if it wasn't for Peter Morris. And I think that's a very true statement. And I remember when I became a candidate standing in the 2013 election, the International Transport Federation was in Newcastle. Peter really encouraged me to attend these seminars that were being run by the Transport Federation, and they allowed me to board a ship in the Newcastle harbour with them. These are people who have international tickets to board ships to check on the safety and well-being of seafarers all around the world. And we were delighted to have them in the port of Newcastle. It was a real eye-opener for me, I have to say, and I'm really indebted to Peter, to the International Transport Federation, for that very early education because, you know, although Peter's report was way back in the 1990s, I was boarding a ship in 2013 that hadn't paid its workers for 3 months, that didn't have enough food for them to get to the next port. But I'm really pleased to say that now with that infrastructure in place and those safety inspectors aboard ships now, that ship left our harbour having paid that crew, having fed them and made sure they had water and food to get to the next port. But it does reminds me that you just need to remain forever vigilant, and Australia, we do have good working conditions for people in our ports, and we want that extended to the people that work on ships that come to our ports. So it was a very, it was an important part of my early education as a, not even then member for Newcastle, but it sticks with me. And that is in no small part to the extraordinary work that Peter Morris did and made sure all of us in the region were familiar with the work that he had done. And that was a good education for me as a young, a young parliamentarian, or as you soon to be. But that Ships of Shame report really elevated public awareness. It strengthened the security of international shipping practices and helped drive improvements in safety standards and conditions for seafarers. And it's something we should be really proud of here in Australia, that we ask international seafarers to abide by those conditions and regulations too. The report reflected Peter's broad philosophy that economic progress should never come at the expense of human dignity, and that workers deserve to return home safely. That fairness matters, and that governments had a responsibility to stand up for those whose voices were all too often ignored. That commitment to fairness and justice defined Peter Morris throughout his public life, and he was deeply respected across the Labor movement because he combined intellectual rigour with a solid grounding in those principles of a high regard for common humanity. He was serious about policy, he was serious about reform and serious about public service, and he understood people, he understood relationships, he understood community, and he understood the importance of humour. For many of us in Newcastle, Peter was far more than a former minister or respected elder statesman. He was a mentor, a confidant, a storyteller, a trusted source of wisdom and advice. He had a remarkable ability to make people feel welcome and valued, and conversations with Peter were always memorable. They could be long and a long journey to get around the story, but it meant that it was really tattooed into my memory bank forevermore. He possessed a razor-sharp political mind and an extraordinary memory, and after leaving Parliament, Peter remained deeply engaged in Newcastle and the Hunter. And I want to acknowledge the words from the now member for Shortland, of just how involved he remained in the Shortland FEC. People after giving service of 27 years have got every right to sit back and retire, but that was never Peter's way. He remained very actively engaged, cared deeply about the rank and file members of the Australian Labor Party, and they loved him for that. And we should all take a leaf out of his book, really. He took enormous pride in the region's achievements and the potential of our region. And just recently, Peter's long-standing contribution to our maritime community was recognised through the ceremonial hoisting of the William IV's new ship tender, the Peter Morris. So he will be very, very chuffed about having a vessel named in his honour. The tender was hand-built by the Lake Macquarie Classic Boat Association in partnership with the William Forth organisation and stands as a fitting tribute to Peter's decades of support and patronage. While I was unfortunately unable to attend that ceremony, I want to sincerely thank everyone involved in bringing that project to life and in honouring Peter in such a meaningful way. It's a beautiful reflection on the respect and affection of our community that our community held for him. He believed passionately in Newcastle's future. He believed in our workers, our industries, our creativity and our resilience. And he believed that regional communities deserved ambition from government, not just attention during election campaigns, but genuine long-term investment and opportunity. And that belief continues to resonate today. I know many across our community will feel Peter's loss profoundly. His passing represents the loss of a generation of leaders shaped by public service, community connection and deep ideological convictions. People who entered politics because they genuinely wanted to improve the lives of others. People who understood that politics at its best is about service. I will miss Peter deeply. I will miss his wisdom, his encouragement, his generosity with younger generations of Labor representatives. I will miss his stories and I will miss his unwavering commitment to Newcastle and the Hunter. I will be attending a service called the Merchant Mariners Memorial Service. Coming up in a couple of weeks, it'll be the June long weekend. That again is a legacy of Peter Morris. He understood that we lost many merchant mariners during the wartime and we had no way to honour them. And we now have at the Newcastle Harbour a magnificent memorial in honour of the merchant mariners. We have a service every year that will happen, as I said, in the June long weekend. And we will all be remembering, Peter will be very much in our hearts and minds at that service this year. On behalf of the people of Newcastle, I do extend my deepest condolences to Peter's family. Peter and his wife Florence, who sadly passed away in 2019, and I know that really hurt Peter. He really missed Flo. But they were loving parents to 4 children, including the late Matthew Morris, their son, who was the former state member for Charlestown from 2003 to 2011. So this is a family that knows service. They're survived by the children of Peter and Flo, Michael, Paul and John Morris, along with Peter's remaining siblings, including one of my predecessors, the former federal member for Newcastle, Alan Morris. He was in this parliament from 1983 to 2001. You know, in my part of the world, if you don't serve for more than 20 years, you're considered a bit of a wimp, I think. I am only the 6th federal member for Newcastle since 1901. That shows the kind of service that has been given. And in no small part, you know, more than half a century of that has been the Morris family. So I do not want to ever underestimate, you know, the significance of that service, and I do want to send my condolences to all the members of the Morris family and to Peter's many dear friends and loved ones, and of course the ALP rank and file, who I know will be mourning his passing. I hope that they take some comfort in knowing that Peter leaves behind an extraordinary legacy, a legacy built not only on the offices he held or the projects that he advanced, but through the values he championed: fairness, dignity, opportunity and service to others. Newcastle and the Hunter are stronger because of Peter Morris, and Australia is better because of Peter Morris. Vale Peter Morris.
I thank Deputy Speaker and Member for Newcastle. The question is that the motion be agreed to. I call the Honourable the Member for Riverina.
Well, thank you, Deputy Speaker, and we've just heard some fine and eloquent words from the Member for Newcastle on behalf of the Labor Party for Peter Frederick Morris, somebody who was obviously ALP royalty, and she spoke about his service to the Federal Electorate Council after his parliamentary career, his extraordinary parliamentary service, the member for Shortland from 1972 through to 1998. and his Ships of Shame report. We will be hearing later on from the member for Adelaide, who no doubt will extol the virtues of Peter Morris, son of a Greek migrant and inaugural member of the World Hellenic Interparliamentary Association, an organisation of which both Mr Georgianis and I are both members. Obviously, good Greeks give good service to the Parliament, and indeed, Steve and I are very good friends. I did not know Mr Morris personally or politically, but having read his record, I pay a deep amount of tribute and honour to him for the fact that he was Minister for Transport, a role I've also held, Minister for Aviation, Resources, Housing and Aged Care, Minister assisting the Prime Minister, assisting the Treasurer, Minister for Transport, Communication Support, Cabinet Minister, Minister for Industrial Relations, Minister assisting the Prime Minister for Public Service Matters. It is a truly remarkable record of achievement and accomplishment and service. And the member for Newcastle spoke fondly about what he had done in and around Newcastle as the member for Shortland and as a Cabinet Minister. But I want to focus tonight, as a Nationals member, on the service that he did for Wagga Wagga and indeed the Riverina, when Riverina was served by a Liberal Member of Parliament, indeed the member for Hume, the late, great Wal Fife. And I went through my bound volumes of the Daily Advertiser. In fact, I got my wife Catherine too, and sent me the material because I was in Parliament when I learned of this condolence motion. And I wanted to speak about it because I remembered, having been a journalist at the Daily Advertiser at the time, that we ran a special 4-page wraparound, which was unusual, but it was momentous because it was an important occasion when Mr Morris came to town. And it was the opening of the new terminal and control tower at the Wagga Wagga Airport on March 26, 1986. And the headlines, the bold headlines, screamed, "Wagga enters the jet age." And a subsequent story, airport upgrade 40 years after Wagga declared a city. And there was Mr Morris opening the airport terminal, which has served the city well since then, but I would suggest that it's probably in need of an upgrade now. More's the pity. I've placed money on the table for the last 2 elections, but we will honour that promise eventually when we get back into government. But there was Mr Morris with the then Mayor of Wagga Wagga, Alderman Ron Harris, and Mr Fife. At the terminal entrance there. The plaque is still proudly on the wall. And it's interesting when you read the article in my newspaper, the Wagga Daily Advertiser, which states that he was embarrassingly late to officiate at the opening. It wasn't his fault. The flight from Sydney touched down 20 minutes late. But he spoke very, very well at that event, and also showed a lot of grace and a lot of humility, which I'll get to in a moment. But work on the airport, which includes a new traffic control tower, new passenger terminal and upgrading of the taxiway, took about 14 months to complete, the Advertiser reported. Before opening the airport, Mr Morris told the gathering it was obvious that the old terminal had its, quote, shortcomings. And I think if he were there to look at the terminal in recent years, he probably would have repeated the same. He said his government was committed to the development of aviation, and good on Labor for that, I will say that at the time. And this is the quote, "We want to make sure that air services are as safe as possible, as cheap as possible and as efficient as possible." Now, as a good aviation minister, he would have recognised the importance of linking country people to capital cities and to other regional towns as well. But he said when there is progress in the air with new planes with better performance, we match that performance on the ground. Now, on the same flight as Mr Morris was the former Governor-General Sir Roden Cutler, who was then Chair of Air New South Wales, and officials from the Departments of Aviation and Housing and Construction responsible for the works. Now, what this upgrade to the airport meant was that the introduction of F-28 flights by Air New South Wales meant that the flight time from Wagga to Sydney has been cut to just 50 minutes at the time. And of course that's the time now, because as the headline screamed and as the headline reported, Wagga Wagga had entered the jet age. Now, at the time, Mr Morris said there were more than 26,000 air movements through Wagga Wagga last year, and he recognised that Wagga Wagga Airport was the gateway to the Riverina, and indeed it was then and it still is now. Now, Mr Morris wasn't a tall man. He wasn't a man of great height. Some might say he was vertically challenged, but I'll take that interjection from the member for Nichols just to get it on Hansard. But I tell you what, he was while he mightn't have been large in stature, he was large in life, and he had a presence. I recall that he had a big heart, and he had a big heart for people, and I think that's important. He was old country Labor, he was old Labor, and but he understood about the benefits of the regions, and you know, being somebody from Shortland, being somebody from outside a capital city, he understood the importance of connectivity, what regional Australia meant to this nation, the fact that people in the regions keep the lights on and keep us fed, and he extolled those virtues in what he did as not only the Aviation Minister, but also, as I said earlier, the Minister for Transport. Both important portfolios, both portfolios that I've held, but so I feel a certain connection to him. And he said that obviously the old system has to be improved. He was talking about planes using Wagga Wagga had to operate on a C and B scene basis since 1962, and the fact that the new control tower had put Wagga into the new age of radar and picking up the planes before that actually arrived. I feel the new airport is warranted and appropriate. He said the old terminal was to be handed back to the Defence Department for use as a terminal for RAF personnel coming through Wagga Wagga. Now, it was important that RAF, Royal Australian Air Force Wagga Officer Commanding Group Captain John McNaughton attended the opening. Mr Morris said it was now up to Wagga Wagga to market its attractions, and indeed I think that was sort of part of the tourism boost for Wagga Wagga as well, certainly. But what I want to get on to is how he summed up, and I think this shows the measure of the man, because in his comments he finished them by, and this is a special politician, because not all politicians would do this. A lot of politicians just want to take credit for everything, and he wasn't a local, but he found out and attributed some of the work, much of the work, to those people who were getting in and doing the hard yards, and he mentioned Martha and Nobby Lamprey, and he said, and I'll just paraphrase it, but it's easy for a politician to stand here, deliver the words, but they helped to make it possible. That couple helped to make it possible. He didn't have to say that, but he did. And I think that shows the humility of the man, the stature of the man, when a person of such high office who'd held any number of portfolios was willing to thank two local people who'd done so much to make that airport terminal opening and control tower possible, and at the same time also acknowledge and respect the work that had been done by his political adversary of sorts in Walfife. And I think that goes to show, and I think we could learn a bit from that. I do, because I don't think that grace is always forthcoming in this day and age of hurly-burly. I mean, I always try to get on with with the Labor Party members as best I can. And I remember when I was a minister, I always invited them, including the member for Newcastle, when we actually took Newcastle Airport, and we got a link with Auckland with some international aviation. It's her and the member for Patterson. I certainly made sure that they were part and parcel of the ceremony, because it is important, because you know what? People respect bipartisanship, and they do. And I tell you what, when you're not in that 6-week madness of an election cycle, I think people give you more points when you actually acknowledge the work done by those on the other side, and I'm always happy to do that. Peter Morris did that. He was an outstanding human being, a brilliant politician, obviously very credentialed. Otherwise, he wouldn't have had as many of those ministries as he was afforded. But he never forgot the little person. He never forgot the man and woman in the street. And the fact that he then served the Labor Party at a branch and FEC level for so many years shows how much he loved the Australian Labor Party, how much he believed in old Labor, and how much he believed in party. Vale, Peter Morris, a fine man, somebody who contributed mightily to this nation and certainly to regional Australia. We will miss him. I pass on my deepest respects to his family. They have given so much to this nation, to the betterment and improvement of this nation, and we need more of the ilk of Peter Morris's in this world today.
I thank the member for Riverina. The question is that the motion be agreed to, and I call the member for Macquarie.
Thank you, Deputy Speaker. I didn't know Peter Morris well personally, but I was a journalist in the Canberra Press Gallery in the 1980s, and I got to do something with him that only a small group of journalists got to do, and that was to seal a road in Western Australia. That was the missing link in having a bitumen road right around the country. Now, we did this on the 7th of September 1986, and there were things that Peter Morris said in the speech that he gave then that resonate very strongly with me now, many decades later, when I have a much deeper understanding of the importance of that infrastructure work that he did. Let me take you back to that time. There was a small contingent of us. I was a radio journalist, so we were travelling there and we were staying overnight in Halls Creek from memory, and we got on a very small plane, a couple of TV journalists, a couple of radio journos and some print reporters. Not everyone coped well with the little flight. I like bumpy flights, not everyone did. And I won't mention Annette's name because she was mortified at the experience. But we landed in Western Australia, having had a little bit of a look at the Bungle Bungles from the air, a place that none of us had ever been. Peter Morris was super excited about this trip. It was a Sunday, so we were all doing this on our weekends, which is probably why my radio station allowed me to go. I have a copy of the media release from the time. Now, it's a shame people can't see this, Deputy Speaker, because it is typed on a typewriter. It's a real blast from the past to see it. And what Peter Morris said, described the day as, was an historic day for all Australians. He said the only event with which this can be compared is the circumnavigation of Australia by Bass and Flinders in their tiny boat early last century. So he was talking about this 2 centuries ago. So this was the last section of gravel road to be sealed between Halls Creek and Fitzroy Crossing. It was a couple of hundred kilometres that were that last section. But Peter Morris got to sit in the machine and do the last spray of seal over the road. He wasn't a minister who just stood back and watched. He got involved. It's a bit hard to capture that on radio, but the cameras had some really good shots of it. But this is some of the words he shared with us there in the speech that he made to the small group who were there to witness this. He talked about that what was being made there appears to be something small, but he said, yet one which will change the face of Australia. He also
And again, this is not something I think I appreciated as a 23-year-old, but he acknowledged the First Nations people of this region when he said when people first passed through this area, they followed ancient trails which had existed since Dreamtime. Then came white man with their herds of cattle, and the Canning stock route was born. He then went on to talk about, in subsequent years, roads being built and how people could drive from place to place. He had, and I think previous speakers have referred to his turn of phrase, a lovely way of describing things. He talks about people could drive from place to place, even if it did mean fighting swollen rivers, ploughing through mud bogs and choking against the dust. So one of the things he mourned was that with the sealing of this road, we actually lose some of that pioneer spirit that he saw was part and parcel of how Aussies had lived. And he did comment that 200 years from now, we're still a little way off that, a new generation of Australians will have reason to remember this Sunday, the day their country was finally linked north, south, east and west. Now, what was really key for Peter, there are some infrastructure ministers who love the infrastructure. There are some defence ministers who love the gear that goes with it. What Peter Morris made really clear was that he loved it for what it achieved and what it did for people. This national highway was actually the largest single civil engineering project that had ever been undertaken by Australians, and at the time was one of the biggest civil engineering projects in the world. But he talked about what those roads mean for people. He said, roads are the arteries, the lifeline along which travels food, medical supplies, building materials, everything. And in human terms, roads mean even more. They bring people together. And certainly as the member for Macquarie, with a large peri-urban electorate of about 4,300 square kilometres, I think roads are absolutely vital, and this has been something in the last 15 years that I've appreciated very deeply. In the Hawkesbury local government area, we have 5,300 kilometres of roads. That's the length of our roads. And 285 kilometres of those roads are still unsealed council roads. And I know the impact they have on my community. In good weather, it might be fine. When they've just been graded, it might be fine. But so often, these roads cause pain for people. They might be inaccessible. They might damage tyres and vehicles. They're a real challenge for people. And we have been working, as clearly Peter Morris had a conviction to seal those roads. The Blue Mountains and Emu Plains, the roads are not so long, but some of them are really old. And when you've got 194-year-old roads like the Victoria Pass, you absolutely know that governments have to invest to maintain, and in the case of the Victoria Pass up at Mount Victoria, to repair and make resilient for the next couple of hundred years. And in fact, I feel like the way Peter Morris described it is exactly what we're facing. In effect, he said, what the federal government is doing with its road building program is to shrink distances, helping to bring more cities and communities closer together. Better roads mean easier, quicker, safer and cheaper travelling, and so more people travel. And he goes on, it was a lovely speech in the middle of a fairly remote area in Western Australia, and he had a beautiful 5-page speech. Now, he, of course, thanked the contractors who made this road possible, and the construction workers got his extra thanks because he said, who, despite the difficult conditions, built this road in a true display of professionalism. So when I saw that Peter Morris had died, I thought about the interactions I had had with him as a young journalist, and this was the one that really stood out. In the old Parliament House, there were many press conferences and many times when he told me things, a lot of which I probably didn't really care a lot about as a 23-year-old. But as someone much older than that now, representing the community that I do. I want to pay respect to the passion and the insight and the understanding he had for the role that he did in his various ministries that touched on infrastructure. I'm ever grateful to him, from suggesting that a bunch of journos might want to jump on a plane with him and head to Halls Creek to watch a machine seal the road. It was a terrific experience. It taught me a lot, and in reflection has taught me even more. So to his family, I concur with the comments that have been made. He gave a lot of his life to service. His family gave much of their lives to serving what was for his dad their new home. And that's the sort of contribution we know migrants and their children and their grandchildren make. I think it's a beautiful opportunity for the Parliament to say thank you for that, and may he rest in peace.
I thank the member for Macquarie, and I call the member for Adelaide.
Thank you, Deputy Speaker, and we've just heard some great words from the member from Macquarie, the member for Riverina, the member for Newcastle, the Prime Minister yesterday, the Leader of the Opposition, about the life of Peter Morris. I can't claim to have known him that well, but I had met him on a number of occasions and spoken to him many times on the telephone, and when he used to visit Adelaide, he would always drop into my former boss's electorate office, Senator Nick Bolkus's office. They were quite pally and friendly, and I got to meet him through working at Nick's office back then. But Peter, of course, was the son of a Greek migrant. His father, Agapitos Montiadis, migrated to Australia and to Newcastle from the island of Simi, which is north of the island of Rhodes on the eastern Aegean Sea, just off the Turkish coast. And if you look at the history of the island of Simi, the majority of people before migration to Australia were actually seafarers. And you can see where Peter Morris had this interest in seafaring and shipping. It was obviously in his blood from his father's side of the family, where, and even today, some of Greece's richest shipping tycoons come from that particular island. That's not to say that Peter was a tycoon, but obviously he had a keen interest, as many from that island do. His mother was Ethel Thomas, who was a Neo-Castrian or Novo-Castrian. I think I got that right. His parents obviously met and set up a house in Newcastle, and Peter grew up in the confines of a fish and chip shop, as many Greek migrant kids did of his era and even my era. So his early life would have been around the small business of his father's in Newcastle, which had a very large Greek migrant population at the time. And Peter stayed connected to his Greek roots and heritage. He had close ties with the Greek community in Newcastle, but also all across Australia and internationally. Peter was part of the World Hellenic Interparliamentary Association, which I'm very privileged to be the Vice President internationally of at the moment. Michael McCormick is a member. But Peter was part of the inaugural group in 1996 that formed this association in Athens with fellow congressmen from the US and senators from the US and Europe and South Africa and South America. And at the time when they were forming the World Hellenic Interparliamentary Association, the Australians, including Peter, were very, very keen and adamant that we have a constitution and bylaws, and they were modelled on the CPA, Commonwealth Parliamentary Association, unlike some of our colleagues from other nations who really didn't quite understand the constitutional need and good bylaws of a organisation. I know that our Australian colleagues, Senator Bolkus at the time, Peter Morris, Dimitri Dollis, who was the leader of the Labor Party, deputy leader of the Labor Party in Victoria at the time, worked very hard, Theo Theophanous, to make sure that it was modelled very similar to the Commonwealth Parliamentary Association. And in fact, this year we're celebrating our 30 years 30 years in Athens with the conference. Michael McCormick and myself will be attending, and I've already spoken to my executive board over there to ensure that we have condolence motions for Peter Morris, and of course for another comrade and colleague who passed away earlier, and that was Nick Bolkus. So there will be an Australian presence there this year. Peter, of course, as I said, stayed close to his Hellenic roots. We were all very proud of him. I remember my parents talking about him continuously, even though they were in Adelaide, had never met him but knew about him. You can imagine migrant workers who had come here with no English, no language, no skills, and then to have one of their own as a cabinet minister. It was a huge thing, and it was actually a huge message to the community that Australia accepts you, and Australia will give you every opportunity, just like Peter Morris. And he was very good at ensuring that he understood that he was the member for Newcastle, but also a role model for Greek migrants all around Australia. He played a very active role, of course, with the Greek community in Newcastle, but also nationally, and lobbied very hard for the Hellenic memorial at the end of Anzac Parade on the left-hand side as we go up to the War Memorial. He lobbied the government at the time to assist and played an active role in the fundraising. And if you look at Hansard, there's a number of speeches that he's made in Hansard promoting and pushing and lobbying for the memorial. And in fact, they started in 1987, the fundraising, and they completed it in 1988 during the commemoration of the Battle of Crete in May, which is coming up next week. And Peter was at the opening and spoke at that opening of the Hellenic Memorial on Anzac Parade. So he played an active role with the Greek community across the nation. He was someone that we all looked up to. And of course, in those days when he came into Parliament, it would have been a very different Parliament. You can just imagine majority men, all white Anglo-Saxon. He would have been one of the rarities in this place. And yet he prevailed, and he became a cabinet minister, Minister for Transport, Minister for Aviation, Minister for Resources, Minister for Housing and Aged Care, and even Assistant Treasurer and assisting the Prime Minister as well. But I think when you look at everything, one thing that really stands out is his inquiry into the ships of shame. And as I spoke earlier, it was in his blood, shipping. And some great work came out of that, where living in Newcastle, one of the largest ports in Australia, you would see ships that would come and go stranded, sailors that hadn't been paid, ships that weren't fit for humans to live on board, etc. And yet, through his international connections after, was able to put some measures in place to ensure that that there are measures in place when things take place. And I was very lucky to know that at a point of time there was a Filipino crew that was in town in Adelaide who hadn't been paid, had no food on board. The ship was embargoed and had to stay in port until all these measures were taken place. And I remember Peter, during this particular campaign, the media was reporting it as a ship of shame. So his work actually resonated in the community for his great work. But look, Peter also had some sadness in his life. He lost his son, Matthew, who also became a state MP. And in fact, I went to a couple of conferences in Athens with Matthew over the years. But he will be remembered by everyone that obviously worked with him, everyone that had dealings with him. He'll be remembered here in this place, but certainly as the Greek Australian media has reported this week, there's been articles on him pretty well every week since since just recently when he passed away. He'll be remembered by the Greek community, and certainly we'll be doing condolence motions at the World Hellenic Interparliamentary Association. I actually had a couple of emails as well from former congressman in the US who knew him, who found out about his death, who sent me an email saying how sad it was. and people as well in Athens who heard about it. Through his connections, it shows what sort of a person he was. He made connections with politicians from all around the world through this organisation. So may he rest in peace, and he will always be remembered.
I thank the member for Adelaide. I understand it is the wish of honourable members to signify at this stage their respect and sympathy by rising in their places, and I ask all present to do so. I thank the Federation Chamber. I call the member for Braddon.
Thank you. I ask leave of the Federation Chamber to move that further proceedings be conducted in the House.
Is leave granted? Member for Nichols.
Leave is granted and I second the motion.
Thank you. I call the member for Braddon.
I move that further proceedings be conducted in the House.
I second the motion.
Thank you, member for Nichols. The question is that further proceedings be conducted in the House. All those of that opinion say aye. Against? The ayes have it. Call the member for Braddon.
I move that the Federation Chamber do now adjourn.
Seconder?
I second the motion.
Thank you, member for Nichols. The question is that the motion be agreed to. All those of that opinion say aye, and to the contrary, no. I think the ayes have it. The Federation Chamber stands adjourned until 9:30 a.m. tomorrow morning.